think Judge Larkin was an attendee. She just sent me a text. She thinks she's in the wrong room.
Okay, we'll look for it.
Okay.
One way.
Yeah. I see. We are live.
Oh, we're live. All right, I'm going to go ahead and call the meeting of the Sentencing Guidelines Commission to order. Today is June 7th, 2023, and this is a hybrid meeting. So we've got most commission members in the room and a couple online pursuant to state law. The first, I'll ask our Executive Director, Nate Wright, to read the roll, please.
Roll call. Estrada? Estrada absent. Ibrahim?
Present.
Ibrahim present. Knutson?
Present.
Knutson present. Ladd?
Present.
Ladd present. Larkin?
Present.
Larkin present. Middlebrook?
Present.
Middlebrook present. Moore?
Present.
Moore present. Morath?
Present.
Morath present. Schnell?
Present.
Schnell present. Chair Mitchell?
Present.
Chair Mitchell present. Madam Chair, there are 9 members present, 1 member absent, 1 seat vacant.
And with that, we have a quorum. All right, so the second item, before we get to the actual business of the day, the second item of the day is recognition of employee service. We are going to be recognizing Ann Wall, who's, I'm going to let Nate start, and then I'm going to pick it up from there.
All right. Thank you, Madam Chair. So this meeting doubles as a retirement party. We just had a retirement. We have a number of guests with us. Many of my predecessors are here, if not all of my predecessors are here. That speaks volume for Ann Wall and what she means to the Sentencing Guidelines Commission and to the state of Minnesota. Ann started with the commission in the 1980s. The commission isn't too much older than Ann is in terms of her public service. And Ann's, it is pretty impressive to have completed almost 4 decades of public service, not just with the Sentencing Guidelines Commission, but most of that with the Sentencing Guidelines Commission. As I think what Professor Wright said, how are we going to get by without the institutional knowledge that Ann brings whenever we had a question? Ann knew the answer if it had anything to do with the history of the Sentencing Guidelines or the Sentencing Guidelines Commission. So Ann, this is your official memento from the state of Minnesota. It reads, Minnesota Sentencing Guidelines Commission presented to Ann Wall with sincere appreciation for your 39 years of state service. Your tireless dedication to the Minnesota Sentencing Guidelines Commission and its mission will never be forgotten. And the date on there is July 5th, 2023, which is the first day of the new chapter in your life as you retire. Congratulations, Ann. Thank you for your service.
It's been a long time, but it's been very rewarding. And I want to thank all the former directors and present director that is here, starting with Deb. Deb Daly was the director when I started. And if it hadn't been for her, I don't know if I would have stayed this long, but she got me started on the right foot and was very good at explaining how to do things and what the guidelines meant. You know, I probably read about the guidelines in the newspaper before I came to this office, but she got me centered on what the purpose of the guidelines was. And so I just was able to grow in the job, move to various jobs. I even served as interim director once, twice, I don't remember. But it's been a long and rewarding career, but it's time to go. So thank you. Oh,
I get to say something.
Thank you. They got me this picture too.
Oh, yes.
I don't know if everybody's seen the picture back here that they got. If I go stand by a little camera, follow me. So this is beautiful. So thank you for that too.
And we're not done. I get to say something too. So I wanted to talk because I have known Ann for quite a long time. I was actually trying to think this morning, when did I meet you? And it was a long time ago. I think I figured it out, and I'll talk about that in a minute. I remember one time you telling me that you used to go get tapes from the courts for the data that we have. You can sit down. And so it wasn't that long ago because we had better technology by then. But when I was a staff attorney at the State Court Administrator's Office when we met. And I don't know if all you remember this, but like a long time ago, the courts were trying to build this new case management system. Some of you may know this as NIDSIS. And my job was to help build the criminal module. And we wanted to make that system better. We wanted to be able to like track what people were actually charged and convicted with and pass that on to the other agencies like accurately. And so Deb Daly said to me, Sentencing Guidelines Commission has this table of all of the statutes that are on the books. You should go meet with them, right? Because Deb Daly by then was working with the courts with us. So I met with you, and I think that was like 2004-ish, somewhere mid 2000s to mid to late 2000s. And you scared me.
No.
You did. I walked in and I was like, oh God, I don't know about this. Like you were all business. You were just all business. That's the way you rolled. I didn't even know if you liked me for a really long time. And I was a little bit scared. But that statute table became the ground for the statute service, for e-charging. Like the four of us in this room, we envisioned that. We made it happen, and you were a key part of that. And the whole criminal justice system is integrated now because of that work. Because you guys started a spreadsheet here at the commission. So I knew then that you were like one of the smartest people I'd ever met. You knew everything about every criminal law that had ever been on the books. Like there was no question we could throw at you that you couldn't answer. It was just crazy. But then I became the executive director here, and that's why I learned you're like the nicest person that I could ever meet. So Ann and I both have family in Pennsylvania, and Ann would go back east to visit her mom, and she'd bring me tasty cakes from Pennsylvania because she knew I loved them and that I missed them. So it was just really sweet. The position here was my first executive position. And I remember the first time a reporter called, I was like, what the heck do I do with that? They didn't let me talk to the press at the judicial branch. I don't know what to do. And she's like, I'll do it. I'll handle it. No big deal. No big deal. By then, she had already been the interim director. She could have been the director. She never wanted it. But you were just like the nicest person.
Thank you.
That I ever met. So I'm going to miss you. The commission is going to miss you. Your work has been extremely impactful. You know everything about the guidelines inside and out. You know everything about the data inside and out. It's going to be irreplaceable. Like we're going to limp along. I know you say that we can get along without you, but it's not going to be the same. That's not
There's so many changes in recent years that I just haven't kept up with. Now Jill knows the guidelines better than I do. She knows the data better than I do, so you guys are going to be fine.
But you helped her get there, didn't you?
And she helped with the statute table. We were sitting in a room entering statutes that weren't there. What was the one that was something you couldn't do with different animals? They were just like, no, let it loose in the streets or something, not something, nefarious. But yeah, there was a fine for that. And like letting cattle run wild or something, But there were all this stuff we never heard of. They were actually on the books. But
yeah, that was crazy. It was crazy and fun. So I have a couple of gifts for you though, because you've been working with guidelines for almost 40 years, like we said, right? So I feel like it's going to be hard for you to make that transition to live without guidelines. So and because you always walk us through the data, I'm going to walk you through your gifts. That's what I do today. So okay, so the first gift that I have for you is this. This is the guideline for how you should live your days. So go ahead and open that.
easier said than done.
I'm sure you said the part.
Oh, you might have to not use say the exact word.
I
Try.
thought it was one of those calendars.
Okay, there we go.
Today.
Retirement weekly schedule, it says. Monday, do whatever the hell I want to do for every day.
And you'll notice there's no departures on the guidelines. So that is what you have to do. It's presumptive that you must do that. But I understand that even if you have guidelines to live by now, you may still miss the grids. So I just wanted to
I
reassure
got
you.
copies on paper at home.
Oh, well, that's good. But I wanted to reassure you that you can still interact with grids every day of your life through your retirement, and that's not going to be a problem. So a couple of things you can do. Number one, if you want to continue to maintain uniformity, one of the key goals of the guidelines, Rubik's Cube, mess that up and then put it back together, get to the uniformity. Number two, if you really need to fill in some cells, figure out what's in the box, get those numbers in there. There's Sudoku. You can do that. Do some of that, and it's even, so you can fill in the grids.
I've never learned how to do this, so that'll be a challenge.
Well, there you go. There is something still to learn. And then last but not least, even candy comes in grid form. I think you could use this as a ranking exercise because, I mean, we all know that in the box, there's some candies that are like less desirable and less tasty. So I think you could probably create your own grid of which candies fit into which cells on the grid. So you have plenty of grids to work with. You have guidelines for life. You will always be part of this family. Congratulations. Thank you. Here, put it down. All right.
I'd like to see if you could solve that Rubik's Cube before the end of the meeting.
We have to go mess it up first and then, actually, if we had messed it up, it would be a lot like what our job is gonna be like today. So then we would try to bring some uniformity, right? Exactly. Well, thanks everyone for indulging me in that. But we do have a lot ahead of us, so let's go ahead and get started for today. I will entertain a motion to approve the meeting agenda, please.
So moved.
Commissioner Shell moves. Do we have a second? Commissioner Middlebrook seconds. Any corrections or discussion on the agenda? Hearing none, go ahead and call the roll.
To the Schnell motion to approve the agenda, Estrada? Estrada absent, Ibrahim? Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin? Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the agenda is approved unanimously. Move on to number 4, which is approval of the draft meeting minutes from May 11th. Those were sent out last week, so you should have all had a chance to review them and entertain a motion to approve the minutes.
So moved.
Commissioner Schnell makes the motion. Do we have a second?
Second?
Second, Commissioner Knutson. Any discussion? Hearing none, we'll go ahead and take the roll.
To the Schnell motion to approve the May 11th meeting minutes, Estrada? Estrada absent, Ibrahim?
I was not present last meeting, so I'll pass on this.
Ibrahim abstains, Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, the big elephant in the room is all of the stuff we need to do today. Item 5 is going through the 2023 session laws. Part A is ranking the newly created or amended crimes. And just sort of as an overview, we do have meeting time scheduled today and tomorrow. My goal is to get as far as we can and maybe even finish today if it's possible, but I'll keep taking your temperature as we go and we'll see how far we get today. So I'm going to turn over to Nate and we'll go with part A.
Thank you, Madam Chair, and I will just, I'll go at the speed that feels right to me. If I'm going too fast or too slow, please let me know. I'd like to begin just by letting you know there were a couple of different versions that I sent out to members of the commission, and briefly we're hanging on online. So the version that we're dealing with is the version dated June 5th. There were a number of small typos and style changes. For example, there's an appendix in this document. There was a page reference to that appendix that was wrong. So we fixed things like that. Also, just a few things to bring to your attention. On page 20, there's table 3. There were several examples of offenses involving substantial bodily harm. Third degree assault, which is kind of the quintessential great substantial bodily harm offense, wasn't on there, so we added that. Jumping ahead to page 31, there's a table 5 that wasn't in the original version. Basically summarizes the felony enhancement scheme for the interference with privacy. It just seemed too confusing to me to try to explain to you without a table like that, so I added that mostly for my own good. It was also an error checking thing because on the next page, I made a mistake in my description of what priors were eligible for the 2-year felony enhancement, and I corrected that on page 32. By the way, we do have printed materials for the commission members if anybody's interested in that. On page 38, there was a missing statutory maximum penalty for the new money transmitter regulations. And then on pages 44 through 46, I'd called the crime originally family and medical benefit insurance fraud. It's modeled after unemployment insurance benefit fraud, which the guidelines just call unemployment benefit fraud. So I took out the insurance word. Obviously, if you want to put that back in, you can, but I'm just trying to keep guidelines as brief as possible. So that's pretty much it. So I'm going to begin by going through these one by one. We talk about, so each one of these crimes requires a severity level ranking decision. You can either leave it unranked, or if you rank it, you should assign a severity level based on the level of harm caused by the offense, the culpability of the offender, statutory maximums, and also how other offenses are ranked in the sentencing guidelines. So is it more or less severe than other offenses, relatively speaking? So that's your first decision. And then there are other lists to be considered. Should it be added to the list of offenses eligible for permissive consecutive sentences? Typically, those are crimes against a person. Should it be added to the severe violent offense list in section 8? That's a very small list for exceptionally severe violent offenses. Should there be an exception to the length of stay? Although I guess that's really a moot point now. And are there other modifications that should be made? So here's our table of contents. So we're going to begin with labor trafficking. That's from chapter 27. So you can see how I've got this organized by basically in legislative order. We've got chapter 27, then 8 offenses in chapter 52 that we need to rank, 1 offense in chapter 57, 2 offenses in chapter 58, and then 1 in chapter 59, and then 3 in chapter 63, the new cannabis crimes. So labor trafficking, we talked about last time, and I don't want to belabor the points that we made last time. I don't really have any new information in here. So really the things that we were discussing last time are how to rank these different offenses. The 5 different ways that labor trafficking has been carved out now under this new statute really present opportunities for ranking these offenses. Labor trafficking resulting in death. And right now the offense is unranked, so the commission doesn't have to rank it, but the legislature has directed the commission to at least consider ranking it. So that's what the commission did last time. So arguably, you've already complied with that directive just by having the discussion that you had at your May meeting. But to consider, but you didn't make a final decision. So to consider ranking it is really your first task. And if you do want to rank it, here are the 5 different ways that the legislature's divided up this offense. And resulting in death, labor trafficking a minor over an extended period of time, resulting in great bodily harm, and just the base offense that's not involving great bodily harm or death, not over an extended period of time where the victim is an adult. And Commissioner Larkin has a question.
Oh, Commissioner Larkin.
On this point, I wonder, since we did discuss this extensively last time, is there anyone who's opposed to the notion of ranking? If not, could we do a motion on that right away to take that piece off the table? I mean, it seems like that would be, is that a separate motion?
I think if there was, that's a really good question, Judge Larkin. So why don't we go ahead and put that to the group? Is there anybody who's opposed to moving forward with a ranking today?
Point of clarification. I have a suggestion on what I'm going to articulate for, and one of them would to have one of them remain unranked with the rest of them being ranked. So I don't know if that goes to that question about unranked versus ranked.
I think that's like a ranking decision.
Okay.
So
Okay.
I think we leave it in that category.
Okay.
So that's good. All right. Judge Larkin, did you have any objections to moving forward? I didn't see you.
No,
Okay.
no.
All right. So I think we are talking about potentially ranking these today. Great.
Another point that I made last time is in some ways, the base offense doesn't apply to some of these offenses, or at least it wouldn't seem to. For example, the debt bondage, it just seems like the way the statute drafts the offense, it would be hard to do without doing it over an extended period of time. Since it talks about a debt that you have, that you owe, that you're trying to pay back with labor, but it's not really being applied to it. It seems like that's almost inherently going to happen over an extended period of time. The other one was the organ harvesting. The forcible organ harvesting, I don't see how that would occur without involving great bodily harm. So that's something that I think actually helps the commission in terms of ranking these things, because in some of these offenses, there won't even be a base offense. So the staff recommendation was to rank labor trafficking resulting in death at severity level 9, great bodily harm at severity level 8, minor victim at severity level 8 over an extended period of time at severity level 7, and the base offense, that is to say, where none of these aggravating circumstances apply, at severity level 6. And all of these offenses, those rankings would allow for a prison commit if there were multiple victims, more than 2 victims. You'd be looking at a presumptive commit as we understand the way this would work. So that's a summary of the other one. The other kind of sticky wicket that we talked about last time is whether to keep labor trafficking on the severe violent offense list. So even though labor trafficking is currently unranked, it is listed on the severe violent offense list when that list was created a few years ago. Arguably, the things about labor trafficking that are severely violent are sort of carved off by some of these aggravating circumstances. So it's possible that the commission could look at this in a more nuanced way than the staff recommendation, which is just to keep it on the severe violent offense list. It might be alternatively that the commission wants to keep the ones involving death, a minor, and great bodily harm on the severe violent offense list, and leave the ones involving extended period of time and the base offense off the severe violent offense list, which would be a bit of a change from the status quo. So I think that's kind of where we left it last time, and then the commission was discussing issues related to that.
All right. So I think open it up for either discussion or a motion, however you guys want to do it. Commissioner Ladd?
Well, I'll just jump in. I know that I brought up some concerns last time, and I've given some more thought to it. And so I won't necessarily repeat myself to what I said last time. But one of the things I was struggling with was the labor trafficking resulting in great bodily harm being at an age where a first degree assault, which is great bodily harm, was ranked at a severity level 9. And I appreciate that the staff included other offenses where there's great bodily harm as a result of an underlying crime. But I still land on the idea that 2 strangers can walk into a bar and one can assault another, and it can result in great bodily harm. And we're going to punish that more severely than somebody who engages in a practice that, by definition of the statute, they are enslaved, they are forced, they're coerced, they're in a condition that's created by the very thing that creates the great bodily harm. And to me, that's very inconsistent. And I recognize that there are some other ones that are differently than that. And so I still land on sort of having issue with that. And so if I can make a motion for the purposes of just discussing, if the chair would indulge me, I would make a motion to adopt staff recommendations, except that the labor trafficking resulting in great bodily harm would be ranked at a severity level 9, and the labor trafficking resulting in death would remain unranked. And so the nuances of those particular cases and specific cases would be addressed through a process with the court on those nuanced facts, what have you, related to the death one, but that's what my motion would be.
Okay, so we have a motion. Is there a second? Commissioner Larkin?
I'll second the motion.
Okay, so we have a motion and a second. Discussion on the motion. Commissioner Middlebrook.
Thank you, Madam Chair. I guess as far as ranking the labor trafficking resulting in great bodily harm, I disagree that it should be at a 9 at the same level as a first degree assault, because I feel like there's, even though the result may be the same with the great bodily harm, the culpability of the offender is greater for a first degree assault because there has to be the specific intent to assault. Whereas here it's a general intent for engaging in the labor trafficking, and the result on the great bodily harm is not intended. So I see a real difference, that I see the first degree assault as a more serious offense based on culpability primarily. And the range of the different things that could happen with the labor trafficking resulting in great bodily harm, it could very well be that there's no intended result there at all, where it's just because of whatever the person is doing, an accident happens or something happens where they end up getting injured. So that's kind of where I feel like the first degree assault should still be ranked higher.
Commissioner Larkin.
Thank
Commissioner
you.
Larkin.
I speak in favor of the motion, and I appreciate Commissioner Middlebrook's statements and attempt to distinguish between the two situations in terms of intent to harm. To that, I would say this, that we have to recognize that, one situation you have intent to harm, conceivably in the other you don't, but in the other situation, the labor trafficking, you essentially are holding someone against their will, putting them in a position to suffer great bodily harm. So I don't know that that's any less egregious, certainly not from the perspective of the victim who has suffered great bodily harm under either scenario. So I'm just not so convinced that the intentional harm of one is much different than the circumstances that lead to the commission of the other. There might not be intent to cause great bodily harm, but you have somebody held in circumstances against their will, which puts them in that position to be subject to great bodily harm. So I think it is, in some sense, it may be worse, because if it's two strangers, one can maybe leave the situation and avoid the harm, but I don't know that a person who's a victim of labor trafficking can do that.
Other discussion? Commissioner Ladd, can I ask you to elaborate on why you're thinking about leaving labor trafficking resulting in death unranked? What would you think? Like, how would that play out if it was unranked, or how would you see that working out?
Well, I see that as an issue for the sentencing court in any given case where that would come up, and the facts and circumstances would be articulated to the court, not only related to the facts of that specific case, but as we talked last week, there are some issues related to some case law on this as well, related to the second degree. Sorry, don't pull it up here. The second degree murder, unintentional. So I think those legal issues around the circumstances for the sentencing court can address those with the facts and circumstances. It may be something that the sentencing court would want to rank it at a severity 11, as an example. It might end up at a ranking at severity level 9, which is the same as great bodily harm. But I think the nuances of those cases are best put before the court on a specific case and to be articulated. And I don't think that we have had a lot of these, or going to have a lot of these. And so I think leaving it to the specific court with the specific facts of any given case is probably the best place where it lies. And so that was my rationale in thinking leaving that unranked, because I do think that there's something inconsistent about initially ranking a death as the same as a great bodily harm out of the gate. But I think that gives the court some range of a possibility to rank it at the same, if that those facts would warrant that or higher. And then the legal argument around that would be presented to the court in that sentencing order.
Thank you. I appreciate that.
So clarifying, so you wanna
Commissioner Ibrahim.
unrank the death one and the rest, it's gonna be 9, the remaining 4, it's gonna be 9 then?
So my recommendation or my motion is that we would adopt the staff's recommendations, except the labor trafficking resulting in great bodily harm would not be ranked at an 8, it would be ranked at a 9. And the labor trafficking resulting in death would remain unranked.
Commissioner Marath and then Middlebrook.
I just have a question. So in practice, is there less nuance when it comes to cases involving great bodily harm, or why have more of a range for the labor trafficking resulting in death as opposed to applying that same, having it unranked for the great bodily harm as well? I'm just confused.
Sorry, I don't understand the question.
Like are cases involving, so you're saying leave it unranked for cases resulting in death?
Correct.
Because, depending on individual circumstances, which I follow. Is that not so much of an issue for some reason with cases that don't result in death but great bodily harm? Or do you understand what?
I don't, I'm sorry.
I guess why
Wondering,
is that? Why
is there a lot of variation in the cases that involve great bodily harm? And if that's true, why wouldn't we leave that unranked as well? I think that's the
thank
question.
you. Yeah, sorry,
Yeah,
I'm having a hard time.
Honestly, I think there arguably could be. I think the struggle that I have, and I brought this up at our last meeting, I think that there's something inherently inconsistent with us having great bodily harm and death as a result to the victim being ranked at the same level, because obviously death is a worse consequence than great bodily harm. And so, and again, the struggle is if you change one of these, the next one needs to get higher. And I think that there would be some perhaps legal challenges for the resulting in death to be ranked at a severity level 10. I think that perhaps that could occur depending on sort of what the sentencing court does with that and the legal arguments that are presented to the court, or it could be an 11. So for me, it really is just the tiered effect that we have here with the base offense starting at a 6 and how it graduates up. It would be somewhat inconsistent to have great bodily harm and death be ranked the same. That's really the struggle. And so leaving it unranked gives that discretion to the trial court, to the parties that are appearing before the court, and arguing the legal standards to the court to make that decision.
I think it was Commissioner Middlebrook and then Commissioner Knudsen.
I had a question on the staff recommendations. Are you also including the consecutive, permissive consecutive, and the severe violent offender list?
Yes.
Okay, so I want to address the, I'm in agreement with those as far as the enhanced provisions, but I think my position would be on, for the base labor trafficking, that not go on the severe violent offender list, because I don't feel that meets the criteria that we've been using to put offenses on there. If that would be ranked at a severity level 6, those offenses that are on there now don't include a severity level 6. They really start with the higher level violent offenses. So in that sense, I would oppose that part of your recommendation also.
Commissioner Knudsen and then Commissioner Larkin.
Well, Commissioner Ladd, you're assuming that we go with your proposal and that they not be ranked the same, death and great bodily harm.
That's correct.
Right. So why don't, it just seems to me that I wonder how many times this is actually going to be charged, and why wouldn't the prosecutor charge second-degree murder instead of labor traffic
Sure.
causing death, resulting in death, so I'm not sure what the difference is would be if we went with severity level 10 for the resulting in death, and 9 for great bodily harm.
Commissioner
Let me
Lack, go
respond.
ahead.
Thank
You can
you.
respond, yeah.
Yeah, I think part of why I landed on this was mostly based on sort of what we talked about at our last meeting, was that there was some, I don't want to say hiccups, but some concern about ranking it at a 10. And so some legal reasons breaking it at a 10. And so trying to avoid sort of all of that in the ranking system, leaving it unranked allows sort of that to occur in a case specific. And again, I think to your point, that is true about charging out as a second degree. Very similar to what I said is that as a prosecutor, if I'm looking at this, I charge out a first degree assault if it's at a 9, and if this labor trafficking is additional elements to have to prove it at an 8, I'm probably going to charge out the first degree assault and not even address the labor trafficking thing. So I think that's probably true with several of these. So I'm not opposed to that ranking at a 10, but I just think that there might be some legal nuances that out of the gate, if we rank it that way, ties the hands of the court to address it differently. So that was that was kind of where I was sort of thinking about this sort of on a graduated scale.
Commissioner Knudsen?
Reading through this, there was the identification of the factors as to why we would leave items unranked. Can you
Director
point me
Bates,
to
can
that
you
again?
remind us of what that is?
Yeah, it's in a comment in the guidelines. Let me see if I can find it. It's
Yeah, it's in there somewhere.
yeah, it's in there several times, honestly, but I don't know if I'm going to be able to find it for you. Let's see.
I think it was in the later materials.
If I could have a minute to look for it, and just actually look at the comments.
Oh, I found it. Page 4. I found it. So an unranked offense typically has one or more of the following characteristics. 1, the offense is rarely prosecuted. 2, the offense covers a wide range of underlying conduct. Or 3, the offense is new and the severity of a typical offense cannot yet be determined. And that's from comment 2A.04. Commissioner.
I just think it's odd that we would rank the less severe elements of this offense, but to leave the most severe offense unranked. And I think the only, well, you can argue anything, but the first is that it might meet the factor that it's rarely charged as a reason to leave it unranked, but I think it meets the other requirements for ranking. Or I don't know, as a sentencing judge, you look at it and what, it's unranked, and what am I supposed, where do we start? What are you arguing? Based on what? And the prosecutor and defense attorney always have to go through the same discussions, understanding, arguments that we're going through on the commission. In just regarding the charge as to how it should be ranked. So I'm in favor of giving the court whatever guidance we can and rank that the death caused by labor trafficking.
Commissioner Larkin.
Thank you. I just wanted to follow up on some of the discussion, specifically regarding sort of the staggered nature of the guidelines. I mean, it occurs to me, arguably, if you commit the crime of murder or great bodily harm in the context of labor trafficking, that crime is worse. In other words, labor trafficking that results in first degree great bodily harm is worse than just straight up first degree great bodily harm. Labor trafficking that results in unintentional murder is worse than a straight up unintentional murder charge. so, I mean, I definitely think great bodily harm, and just so people aren't familiar with the guidelines, if it's a first degree assault resulting in great bodily harm, will you rank it at a 9? And I think what Commissioner Ladd is saying is, well, why wouldn't we rank labor trafficking resulting in great bodily harm at a 9 as well? And I guess what I'd throw out is maybe labor trafficking resulting in great bodily harm is worse, and it should go up to a 10, and the death should go up to an 11. Because just conceptually, it seems to me, if you have 2 crimes, the end result is the same, but one was committed because the victim was particularly vulnerable because they were being trafficked. That seems like it's worse. So I think we should maintain those distinctions. And if we don't want to leave death unranked, maybe what we should be doing is saying labor trafficking, great bodily harm, that's a 10, and labor trafficking, unintentional death, that's an 11. That maintains the hierarchy.
Okay.
Madam Chair, members, I just, as I looked through and I read through the kind of staff recommendations, it just, and I think about things like, and I hear George Larkin's comments about the severity, and I can't disagree. I start to think about like what's involved in the conduct. And I think about things like kidnapping with great bodily harm. It seems that you know there's a corollary, and it's more consistent, and that made sense to me in terms of looking at some of the recommendations, and I think the levels of I also am the intent to cause that harm. When I think about first degree assault resulting in great bodily harm, I think it made the arguments of the staff in terms of recommendations seemed to made some sense to me. And I'm concerned about like going outside, and I'm also struck by a move by Commissioner Knudsen, Judge Knudsen's kind of comments around, you know, the fact that, you know, if I could only imagine myself being in that position of having to make, you know, listen to the arguments and what are the arguments based upon, it makes some sense to me that to have the offense resulting in death also, you know, on the guidelines and spelled out. So I say that because as I'm thinking about it, and I hear the arguments, and I understand the arguments that people are making, but it did seem like it made the staff recommendations just made sense overall when you try and put this into some context. That was my sense.
Just to be clear, you're opting in favor of the staff recommendation.
Yeah, I'm just laying out kind of where, you know, where my thinking is, and as I read through all of the arguments that staff made, it made sense when you look at the totality of the conduct and the rankings of other crimes.
Oh, I'm sorry, Commissioner Larkin? Commissioner Larkin.
And Commissioner Schnell, thank you for those comments. That's actually very helpful because you said something very useful there. Labor trafficking resulting in great bodily harm seems sort of equivalent to kidnapping resulting in great bodily harm. And I agree with you because there's that extra element of the perpetrator taking the victim or holding the victim against the victim's will. But if you look at the staff recommendation, kidnapping with great bodily harm is ranked at a 9. So I don't know why we wouldn't rank labor trafficking resulting in great bodily harm at least a 9. That seems consistent. You have the great bodily harm and one of 2 other things, either kidnapping or labor trafficking. But I don't think it makes any sense to rank it at an 8 where you just have the harm and not the additional circumstances that additionally preys on the victim and is additional culpable conduct. I think one thing that stands out in my mind is Commissioner Ladd's statement that, well, as a prosecutor, you know, why am I going to charge it in a way where I have to prove this additional fact if it's not going to result in any greater penalty? So based on your comments, Commissioner Schnell, I think 9 is definitely where we want to put labor trafficking resulting in great bodily harm. And I hear Commissioner Knutsen's statements. I agree. When I was a district court judge and I saw an unranked offense, it's like, what's the point of the guidelines? They're supposed to tell us what to do here. Why do I have to turn into the Sentencing Guidelines Commission? So maybe, you know, we do rank labor trafficking resulting in death. I see the problem doing it at a 9. I mean, on one hand, or a 10, on one hand, it's good because that's above great bodily harm. On the other hand, there's nothing to really distinguish it from a regular second-degree unintentional murder that isn't related to labor trafficking. That was the only reason I suggested 11. Do we have kidnapping resulting in death, or is that simply a second-degree garden variety?
I believe that's separately covered under the murder statutes. I think that's a special form of first-degree murder.
Yeah, it is.
Oh, so that's a first degree.
If I'm not mistaken, yeah, I think there's a special provision for kidnapping.
If kidnapping resulting in murder is first degree murder, which is life, I mean, why would we have any hesitation, you know, based on what Commissioner Schnell is suggesting is sort of equating the kidnapping and the labor trafficking, and at the very least saying labor trafficking resulting in death, it gets you to 11.
Well, that may be intentional. It may be limited to intentional murder. I'm going to have to do a little research on this and get back to you, please.
Nate's gonna check that out. I know that Commissioner Schnell wanted to just reply quickly.
So I appreciate that, and you know, as I'm thinking through this, so just looking at, you know, kidnapping with great bodily harm is a 9, but then you have malicious punishment of a child resulting in great bodily harm is an 8, and manslaughter, child abuse is a 9. So this is where I'm struggling with trying to make these things make some sense relative to, you know, the really horrific outcomes of these cases. And so, I mean, when I was looking at kidnapping, I really meant to talk about that in terms of, you know, where that sits, but I'm also struggling with things like malicious punishment of a child as an 8. And then, you know, how does the particular vulnerability of a victim, it seems, would be somewhat equivalent in my mind between the malicious punishment of a child resulting in great bodily harm and great bodily harm resulting from labor trafficking. And then when you go up to manslaughter 1 with child abuse, that sits as at a 9 as well. So I guess just to clarify my position, I think this is where I'm supportive of the recommendations of staff, and but obviously we can all see the challenges with how we are thinking about these particular crimes and the factors, the levels of vulnerability and so forth. And so to me, the child abuse or the malicious punishment of a child seems somewhat similar.
I was gonna actually make the same comment if you hadn't made it. But Commissioner Ladd, if you wanted to respond?
Yes, just a couple of things. First to Commissioner Knutsen's comments about leaving the death unranked. I will just tell you as a prosecutor, I don't like that. I like to have some certainty with what the judges are going to do, but I know judges like discretion, but I would just say this, that I think that a judge is going to look at, is that me? I don't have my computer on. Okay, they're going to look at labor trafficking with great bodily harm as a 9, and I think that at a minimum, the death is going to come in at a 9 or higher. So I don't know that it leaves a lot of uncertainty for the trial court judge and for the practitioners in that specific case to say, gee, what should we do with this? Should this be a 5 or should this be, I think that rationally, because the great bodily harm would be at a 9, I don't think that would be less than that. And I think there's some assumptions on my part that way. I think the other thing that I was looking at this too, and to Commissioner Chanel's point, we're not here to debate sort of the other rankings, and I don't know that I necessarily agree with those, but they are what they are. But I also look at what the stat maxes are on some of those other things. And if you look at the stat max here, we're talking about stat maxes being 20 years for the 20 years for the great bodily harm, and some of these other ones, the stat max are significantly less. And again, I'm not going to debate those other ones, but and again, that's probably a topic for another day on a comprehensive review of the sentencing guidelines. But so I look at that too in terms of what the stat max is, and I think that imports some level of seriousness, if you will, for that underlying offense. And so again, I think that is supportive of sort of why I'm indicating that the great bodily harm should be ranked higher than it currently is in the staff recommendations.
Okay, Commissioner Middlebrook and then Commissioner Larkin again.
Thank you, Madam Chair. Just to add to that on the stat max, particularly for the labor trafficking resulting in death, the stat max is 25 years, whereas the severity level 11 is 40 years. So I think the legislature has really sent a signal that they don't equate that with a second-degree intentional murder, they do equate it with something less than that based on that. And they also made a specific reference in this statute that it's not, this would apply when it's not a second-degree murder, first or second-degree murder. So I think that they've signaled that to us as well, that they're looking at it as less than the equivalent of a second-degree intentional murder or a first-degree murder.
Madam Chair,
Nate?
I just want to correct the record. In speaking about kidnapping is mentioned in first-degree murder, but that must be an intentional act. So, and I believe that's also mentioned in 609-106, the heinous. I think that's mandatory life without possibility of release, if I'm not mistaken. But to be, if it's not intentional murder, then it would be felony murder, second-degree felony murder.
Okay. Commissioner Larkin? Did you have another comment? If you're talking, you might be muted.
I'm so sorry. I wonder if Commissioner Ladd would be willing to accept an amendment wherein we would adopt the staff's recommendations, except rank labor trafficking resulting in great bodily harm at a 9 and labor trafficking resulting in death at a 10. I just don't see how we can justify using an 8 for great bodily harm when great bodily harm without any attendant circumstances having to do with labor trafficking is ranked at a 9. I think we have to be at a 9. And then death, I don't know how we rank it at a 9 or an 8, I'm sorry, at a 9, if we put the great bodily harm at 9. So I think 10 and 9 are good numbers. And the reality is judges have the ability to do departures up or down if the circumstances warrant it. But going with 9 for great bodily harm and 10 for death is consistent with how those offenses are treated when you don't have the additional harm caused by the labor trafficking. So I don't know if Commissioner Ladd is willing to do that. If so, I would second it.
Commissioner Ladd, would you accept that amendment?
Was Commissioner Larkin the second on my motion?
I actually was going to ask because I don't remember.
Yes.
Yes, she was.
Yeah, glad one.
Yeah, she was.
I would make that amendment to my motion.
Okay, so you have amended your motion to rank great bodily harm at 9 and death at 10. And then Commissioner Larkin, you accept that amendment as second?
Yes.
Okay. So the
And then the other thing I was going to ask, Madam Chair, is I think unless there is a connection, and I don't know if there is, I think it would be useful for the group, because this does get to be confusing, if we just decide the rankings, and then once we voted on that, move on to the second issues of permissive consecutive sentencing and severe violent offenses. And
Everybody here is nodding their head in agreement, so that's a great suggestion, thank you.
So what was taken out?
So we're not gonna deal with the severe violent offense or consecutive sentencing at the same time as the ranking, we're gonna do those separately. So this is only a ranking motion right now. Okay.
And that division is also a friendly amendment?
Yes.
Yes.
thank you, Nate. Keep us on track.
Keep us honest, yeah. Perfect,
Yeah.
okay. Any further discussion on the amended motion? All right, hearing none, I think we vote on it now.
All right. I'm just going to restate this so we're all clear. So to the LAD motion to rank labor trafficking resulting in death at severity level 10, labor trafficking a minor at severity level 8, labor trafficking over an extended period of time at severity level 7, labor trafficking resulting in great bodily harm at severity level 9, and labor trafficking, the base offense, at severity level 6. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes,
Larkin, yes. Middlebrook?
No,
Middlebrook, no. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
No,
Schnell, no. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, 2 votes opposed.
With that, the motion is approved. So then we move on to the second question, which is, should these be on the severe violent offense list and on the offenses eligible for permissive consecutive sentences list? So do we have Commissioner Middlebrook?
question first,
Yes.
Madam Chair. Are we splitting those as well?
We could do it however people want to. If you would like to make a motion, you don't have to make a motion to both. If you just want to choose one.
Yeah, I will make a motion to, for the severe violent offense list, that they all be added, all be put on there except for the base offense of labor trafficking.
Okay. And do we have a second for that motion? Commissioner Knutson seconds. Any discussion? Commissioner Larkin?
and this is just so I understand. So labor trafficking is currently on the severe violent offense list. So the motion is really to take section 6 off the list. Do I understand it correctly?
Yes.
I don't think is it on there now?
It is.
Oh, the whole thing is on.
That's why the staff recommended just status quo, keep it on. But
So,
Why,
yeah,
could I ask Commissioner Middlebrook, why do we want to take section 6 off the severe violent offense list?
Commissioner Middlebrook.
Thanks, Madam Chair. The reason I'm moving for that is to be consistent with what we decided on the sex trafficking offenses, and the base level was not included on that. Historically, labor trafficking was the only one that was on there. Sex trafficking wasn't even on the list of severe violent offenses, because based on what I recall from all that discussion, they're kind of lumping them all together. But only labor trafficking got listed there. And it seems that we should be consistent, and it's also, for ranking it at a severity level 6, it seems that it should not be included. It doesn't meet the criteria that we have been looking at for that list.
And
I'll,
did
Oh, go ahead, Commissioner Larkin.
And I was gonna say, so it's a 6, so it's a presumptive probation, 21 months. It's a pretty low level ranking, so is the thinking that that doesn't coincide with the severe violent offense, which makes sense to me.
Correct. Yeah, you may not have heard it, but she did acknowledge that is what she's thinking. Any other discussion on that motion?
If there was a second, I missed it.
Oh, it was Commissioner Knudsen.
Okay.
Okay, I think we should go ahead and vote then.
To the Middlebrook motion to remove the severity level 6 labor trafficking offense from the severe violent offense list. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, I just point out there is no action required to maintain labor trafficking on the list of offenses for which consecutive sentencing is permissible.
Oh, okay, so we'd only have to do that if one of these isn't going to be on there, basically. Is that what you're saying? We only
Right.
have to take an action if we wanted to change that status.
Yeah, I mean, the changes that are in there are all technical changes that staff would go ahead and make if you didn't take any action. I'm just pointing that out. You can make a motion, but the
Okay,
staff will understand the changes to be implied by status quo.
okay, so is there anyone who wishes to make a motion to change the inclusion of labor trafficking on the permissive consecutive sentencing list?
So all of them would be on there.
It is on there now.
It's already on there. The question is, does anyone want to change that? So it's not on, like maybe one of these is not on there. If anybody wanted to do that, now would be the time. If anyone doesn't, we don't have to do anything. Commissioner Middlebrook?
Again, I'm looking at, I've got a question first, Madam Chair. What's listed for the permissive consecutives, is it only the sex trafficking first and second degree?
All sex trafficking offenses are listed.
All of them?
Yeah,
Okay.
we just break them out by sex trafficking and aggravated sex trafficking, but they're all there.
Okay.
Okay, so I'm not seeing anybody wanting to change that status. So we're going to leave all of the labor trafficking offenses on the permissive consecutive sentencing list. Good?
Sounds good.
All right.
All right, and Madam Chair, this is probably a good time for me, or maybe a little late for me to say that we are understanding that all motions to change the guidelines are in fact motions to
Yes.
forward these changes, advance these changes to a public hearing, which will happen in July, et cetera. But,
Yes.
so nothing is final today.
Thank you for the reminder. Yes, that is an implied part of every motion today. Okay. So now we're moving on to the items in chapter 52, the Omnibus Judiciary and Public Safety Act.
All right, so.
I'll let you take a moment to get there.
Thank you, Madam Chair. Okay. So the first offense in the omnibus crime bill was new crime of carjacking. And basically, in a nutshell, carjacking is robbery, but it's more specific than robbery. It requires that the property taken be a motor vehicle, and it requires that the property actually be taken, which isn't necessarily required by robbery. So and the statutory maximums and the elements are otherwise identical. So the way staff looked at this crime is it's almost not even a new crime. It's just a more specific version of robbery. And staff did not detect any legislative signals that this offense be treated more seriously than robbery is now treated. So staff's recommendations, again, with our status quo bias, which we talked about at the last meeting, or to keep these ranked the same as simple robbery, that's identical to third degree carjacking, second degree carjacking, and that's ranked at severity level 5. Second degree carjacking is the same as second degree aggravated robbery, which is ranked at severity level 6. And first degree aggravated robbery is ranked at severity level 8. That's the same crime as first degree carjacking. So staff's recommendations are to keep that the same. It's not to say that there isn't some precedent for the commission considering crimes involving motor vehicles to be more serious than other crimes. I'm thinking of theft statutes in particular. But in the absence of any legislative signal that this should be treated differently, and listening to some of the hearings about this, it really did seem to be more of a categorization decision than, so that we can sort of identify what these crimes are and call them for what they are, than a penalty enhancement. And obviously, the legislature is more than capable of increasing penalties if it wants to send that signal to the Sentencing Guidelines Commission. It would ordinarily increase the statutory maximum, but the legislature very clearly chose not to do that in this case. So that's the staff recommendation to rank carjacking first, second, and third degree at severity level 8, 6, and 5 respectively. And to add carjacking to the list of offenses eligible for permissive consecutive sentences, because that's where robbery is, and to add first degree carjacking to the severe violent offense list because first degree aggravated robbery is on the list. That's all I have on that, Madam Chair.
Commissioner Schnell.
Madam Chair, I would move the adoption of staff recommendation.
All right, we have a motion for that. Commissioner Middlebrook seconds. Any discussion on the motion? Are we dividing the other two issues all the time, or do you want to?
Madam Chair, just because it was like all part of the paper recommendation, I was thinking about the package in this one.
So the consecutive sentence and severe violent offense, go with those recommendations.
Because it's all consistent with
Okay, and then Commissioner Larkin, did you raise your hand?
I did, yes. I would like some discussion on this issue.
Sure.
I appreciate that the legislature may have done statutory maxes that are consistent with robbery, but I really have to question whether there are no signals that the legislature doesn't think of carjacking as worse than robbery. The reason I say that is because, we've had tons of carjackings in the record, in the media, in the news. And despite the fact that we've had a legislature that's been, very pro-defense, nonetheless, this is one area where they came up with a new crime. And there really was no reason to come up with a new crime because, as Nate has pointed out, the elements are, you can't commit a carjacking without committing a robbery. So to the extent that the legislature nonetheless decided to commit this new crime when it didn't have to, and I assume it was probably in response to public concerns about carjackings and the number of them. And as Nate's pointed out, crimes involving automobiles can frequently get much worse, as we saw with the bus stop incident recently and the 12-year-old fellow who was driving that car. I guess I'm not so sure that these offenses should not be ranked one level higher than the companion robbery offense, because I don't understand why this offense was created if the legislature didn't want it to get more serious treatment.
Commissioner Schnell.
Madam Chair, I don't want to, certainly don't feel like I can speak for the legislature, but I would just say that I would concur, just having sat through a lot of those discussions, when there was conversations about the distinctions between, the data around robbery versus carjacking, the distinction itself was oftentimes hard to really get a handle on what was happening because of the way these cases were charged as robberies. In some cases that the arrests they were booked under robberies. And so it was really difficult in some cases for them to recognize what of these robbery cases were carjacking, car related robberies versus more standard first degree robbery. So that, and again, I don't want to pretend, but just listening to a lot of the conversation, that seemed to be a part of this. I don't want to minimize it by any stretch of the imagination, the critical nature of it, nor the increase in the number of these cases, in particular, particularly in Minneapolis, has been the place where this has been a really, not that other places as well, but if you look at the data overall, that's where there has been more challenges. And so that's why I would support that, just based on having sat through a lot of and hearing a lot of that discussion. Again, I don't minimize its seriousness.
Okay, Nate has a point to make, then Commissioner Larkin had her hand up, and then Commissioner Ibrahim.
Thank you, Madam Chair. Just to follow up on Commissioner Schnell's point, not to overemphasize the impact of the Commission's fiscal notes on the legislative process, but I will say that this is what staff assumed the Commission would rank these offenses at and stated so in our fiscal note. And I didn't detect any legislative pushback on that, like that there was, they were shocked that we were assuming that carjacking would be ranked the same as robbery.
Commissioner Larkin.
Okay. Thank you, Nate. That is helpful. I still think carjacking is worse. I mean, robbery can be, I grabbed somebody's backpack as they were sitting on the bus next to me. In carjacking, you're actually taking someone's car. There's a risk of harm that comes from, the traffic situation in which it occurs. There's a risk of harm caused by driving it away in a stolen vehicle, and maybe you cause a chase and maybe someone gets hurt there. And then there's also just sort of the financial impact to the victim. I mean, if you have a car and then you have to survive without one, it's very difficult. So I do think this is worse than just a regular robbery. And I don't know, I would advocate still that the Commission consider whether we should treat it worse in terms of sentencing. Going up from 5 to 6, 6 to 7, and 8 to 9 doesn't cause anyone, who has low or no criminal history to go from probation to prison. It just results in a little more time and perhaps sends the message that this is a crime that we're going to take seriously for all of the reasons that have been discussed.
Commissioner Ibrahim.
Thank you. I do want to say that if the legislators kind of sent this over as a new statute by itself, a standalone, and that we have been dealing with this issue ongoing, especially with this carjacking, I do believe that some of these should be ranked higher based on the severity of it, because like Judge Larkin said, it does come up with a financial impact, but it also comes up with a lot of mental health impact, being a victim in that situation, because it does take a while to recover from it. And my sister recently dealt with this same situation where she got carjacked and did not want to drive that vehicle for a while. It does come up with a lot of kind of emotions behind it, and it's an ongoing issue that, Minneapolis is dealing with it, but I think a lot of the parts of other cities are also dealing with it, because whether it's kids or adults who are doing it now, I think and the public, I think, have been asking for kind of the consequences behind it, and the impact it has on the community right now is severe. So I think if this is going to go to a public hearing down the line, I think we should move it at a higher ranking and see what the public also says about it.
Thank you. Any other comments, Commissioner Knudsen?
Well, I'm just concerned about the rationality and the proportionality of this new offense with robbery. The elements are the same, the statutory maxes are the same. The legislature didn't give any indication that it should be, they're expecting punishment or sentencing more severe than robbery. I just think we do ourselves and respect for the guidelines a disservice when you've got the same elements, you've got the same statutory max, essentially it's a similar crime. And the emotion that goes with being robbed or held up by a weapon is very similar, I would expect, to a carjacking. And the legislature just hasn't indicated that it should be anything different. So I guess I'm looking at the rationality and the proportionality of this crime compared to robbery, and I think I would support the staff's recommendations of the motion.
Any other comments? All right, I think we can go ahead and vote on this one.
All right, to the Schnell motion to adopt staff's recommendations with respect to the crime of carjacking. Estrada? Estrada absent. Ibrahim?
No.
Ibrahim, no. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
You might have been muted, we couldn't hear you.
Larkin?
I apologize, no.
Larkin, no. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, 2 votes opposed.
All right, with that the motion passes.
All right, the next. The next offense on the list is kidnapping. This doesn't change the offense, it simply numbers the aggravating circumstances. So kidnapping is normally a 20-year felony, but if there are any of 3 aggravating circumstances, the offense, the maximum penalty doubles to 40 years. And the act amends those 3 aggravating circumstances as follows. Small Roman numeral 1 is the victim is not released in a safe place. Small Roman numeral 2 is the victim suffers great bodily harm during the course of the kidnapping. Small Roman numeral 3 is the person kidnapped is under the age of 16. There were no substantive changes to the law. I'll just say kind of a side note on how the sentencing guidelines work. Typically, the sentencing guidelines do require some kind of a subdivision or enumeration to rank something differently. Kidnapping has been an exception where it's all lumped in under one, but the guidelines take one clause and say, we're going to rank that higher than this clause and so forth, which always has made me nervous. There are some other crimes that are like that right now. So I'm frankly a little bit relieved that this is done. So I think this allows the commission to simply clear up the sentencing guidelines where great bodily harm continues to be ranked at severity level 9, but now it's under Little Roman numeral 2, and not being released in a safe place, a victim under 16 continued to be ranked at severity level 8, but now it's under Little Roman numeral 1 or 3. So we're recommending essentially conforming recommendations, but I guess we didn't put this under the conforming recommendations. These are rankings because these are new enumerated subdivisions, but we're essentially recommending status quo. We're also doing some cleanup here. I think the term unsafe release is a little misleading. That's how the guidelines currently term that, but it not released in a safe place doesn't imply any sort of release. So unsafe release implies that someone was released in an unsafe manner, but if the person wasn't released at all, that also is covered by not released in a safe place. So we changed that to conform to the statutory language. But other than that, it's, the recommendations are simply to conform the sentencing guidelines to the new enumeration of clauses in the statute.
All right, does anyone want to offer a motion for this one?
Madam Chair, I would move.
Commissioner Middlebrook.
Madam Chair, I would move to adopt the staff recommendations to make the conforming and technical changes to this regarding the kidnapping.
Great, and then.
Second.
Oh. Commissioner Knudsen. Second.
I prefer the left room.
All right, do we need any discussion on this one? Not hearing any, let's go ahead and take the vote.
That's about how much discussion I got at the legislature too, Madam. To the Middlebrook motion to adopt staff recommendations to make conforming and technical changes regarding changes to the offensive kidnapping. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
and with that, it passes unanimously.
The next offense is, so this is fictitious emergency call or swatting. Is where somebody calls the police, calls 911 and says there's an emergency at a particular location. So police respond sometimes with a SWAT team, which is why it's called swatting. And that can create a dangerous situation. So right now there's a felony with a 10-year statutory maximum if the call triggers an emergency response and someone suffers great bodily harm or death. And then it's a gross misdemeanor otherwise. So there's a big gap there between great bodily harm and nothing. And so the law just fills in that gap with a substantial bodily harm level. So if somebody suffers substantial bodily harm but great bodily harm in response to an emergency response that's generated by a fictitious emergency call, then that is what we're talking about here. It's got a 3-year statutory maximum penalty. So, and we list here a number of other offenses that result in substantial bodily harm. We're recommending ranking this at severity level 4, which is the same as that of fleeing a police officer in a motor vehicle resulting in substantial bodily harm. It seems kind of similar. You've got misbehavior resulting from implicating a law enforcement response, and then because of that law enforcement response, someone gets hurt. It's a little bit lower of a statutory maximum, so maybe you'd want to rank it lower, but 3 years does just barely fit within severity level 4, where the upper range at the maximum criminal history equals 36 months. We're also recommending adding the new offense to the list in section 6 of permissive consecutive sentencing. So that's the staff recommendation, Madam Chair. Oh, and we are recommending just shortening the offense title. It's pretty long right now. I think fictitious emergency call makes it pretty clear what the offense is about.
All right, any discussion on this one?
I have a question.
Commissioner Ibrahim, did you
Nope.
want to make a motion? Commissioner Larkin?
All right, so there's a new offense where it's swatting resulting in great bodily harm or death. What is staff recommending for that offense?
So that's an existing offense. We're just recommending shortening the title of that. That's currently ranked at severity level 8, and that offense has not changed.
Okay, all right, so what are you recommending to rank it for?
Other than numbering the clauses, that offense has not changed.
Okay.
We're recommending ranking that new intermediate level offense at severity level 4.
So that's a substantial bodily harm.
Correct.
Okay, thank you for the clarification.
Thank you for the question.
Commissioner Ibrahim,
Nope, I just would like to move it.
what would you like to move? You want to follow staff recommendations or,
Follow the staff recommendation.
any second for that?
I'll second.
Commissioner Schnell seconds. Commissioner Middlebrook, did you have your hand up? Sorry, I saw you had a.
Yeah, Madam Chair, I just wanted to weigh in. I feel like it should be a severity level 3 just because assault third degree is a severity level 4 with a 5-year statutory max. And this is not the resulting in substantial bodily harm is not the intentional act. It's not a specific intent there. And fleeing a police officer, to me, the underlying conduct when someone is deciding to flee a police officer seems to be more serious than making the fictitious call, emergency call. And there's also kind of a real wide range of behavior here. I guess what comes to mind the most is, somebody, teenagers especially, or kids playing a prank on it. So, calling it in. So I just see there's a real wide range that it doesn't seem like it is the equivalent of fleeing a police officer resulting in substantial bodily harm.
Commissioner Larkin, did you, is your hand up from before or did you just raise it?
I apologize. It was up from before.
No, no problem. I guess I found this one very difficult. But I actually would echo what Commissioner Middlebrook said. I keep trying to think about what is the behavior that the person engaged in, and the person made the emergency call without intent, hopefully, of somebody being harmed. And the harm happened as a result of the call. So it felt, I've really struggled with this one because the other similar offenses that were pointed out to us have that 5-year stat max, but the legislature seems to be signaling to us that this is somewhat less serious with that 4-year stat max. So I really struggled between 4 and 3. 3 felt a little bit better to me than 4 as well. Any other discussion?
Who seconded the motion?
Schnell, Commissioner Schnell.
So-
Commissioner Schnell.
So the challenge for me on this, I keep trying to think about like, what would be the fact set
Yeah.
that result in this outcome? And, and that was really part of that's the challenging part about this is what does that look like? Is that the response to something? Is it law enforcement, doing something with regard to like exigent circumstance entry? I mean, what would be the facts that would support that type of offense? And that's where it becomes, I think, both difficult, but it also, I think about the substantial risk factors that are present given the dynamics. That's the hard part here, is that the intent may not certainly be to cause that harm at some level. At the same time, there was a response that was generated as a result of that thing that could have significant consequences for the people where that goes. So that was really, this is the hard part that I struggled with, and that's why I guess I could be supportive of it. I also understand, when you look at maybe who's committed many of these offenses are going to be youth. That has been a lot of them. So I guess that's why I landed where I was in terms of supporting this. At the same time, I understand the other dynamics.
Yeah. Madam Chair?
Oh, I'm sorry, Commissioner Larkin.
I know, because I'm messing around with this hand thing. It's confusing. I struggle with this one, honestly, because when I look at the list of other offenses resulting in substantial bodily harm, every one of them except fleeing a police officer involves sort of action directed at a particular person. And we don't have that here. And fleeing police officer, I just think, and I assume that's by motor vehicle, right? So
Yes,
that's worse. I mean, I could be persuaded that 3 is the right one for this offense.
Commissioner Knudsen.
Madam Chair, I would agree with, did you make the motion? No, we're
Commissioner
arguing
Ibrahim made the
about-
motion.
Oh, we're arguing about whether or not we got the recommendation.
Right.
That it's kind of like the same discussion that folks are having, the legislature is having about felony murder. You didn't intend the murder, but it happened in the commission of this offense. It's really not intentional. And that's kind of to answer the commissioner's question, what are the facts surrounding this kind, how would this result by making that 911 call? You're trying to mesh different actions that aren't intended.
Commissioner Moore and then Commissioner Ladd.
I agree. I see felony fleeing a peace officer in a motor vehicle as having a degree of intentional recklessness that is more connected to the behavior of the individual and the threat to the public. I mean, I respect what Commissioner Schnell's saying. I mean, they both implicate public safety concerns. Swatting, to me, seems a degree different. So I too think it's a close one, but I could be convinced that it's a level 3 as well for that reason. I just, in terms of the egregiousness meter, if there is that such a thing, you know, I don't know. Fleeing a peace officer in a motor vehicle is a different animal to me.
Commissioner Ladd and then Morath.
Thank you. So I just have a procedural question. So you should probably know this for how many public hearings we've had. So like if this gets ranked at X, whatever it is, and we have the public hearing, and then after that, we can make it be, if we rank it at 4 and after the public hearing, we want to make it a 3, we can do that. Or if we have the public hearing on 4, how does it, I just want to know how that works to get, like, can we change it after we get that? I mean, how does that work?
If we got feedback from the public that suggested that 3 was the more appropriate ranking and we had suggested it should be 4,
Okay,
then we absolutely could change it
okay.
at that point. If we didn't get that kind of feedback at the public hearing, then it would be harder for us to justify
Okay.
changing our initial ranking. But that's the goal of the public hearing,
Sure.
is to give us a chance to take additional input in before we make a final decision.
And I just would, without belaboring what everybody else has said, I think that I share the same concerns as my fellow commissioners in terms of just, I do see like fleeing a peace officer in a motor vehicle as very different conduct than the phone call that sort of would end in the same result that way. So there's a little bit of a disconnect with the nexus that way in terms of being same consequence. So I could be persuaded to be at a 3 instead of 4 as well.
Commissioner Morath?
I just have a question. So with the swatting, is there somewhere in the language that it means all calls would be with no intention to cause harm? Or is it possible that somebody with the intent of causing harm using swatting just as the means? Is there a way, or is there somewhere in the language that does make that distinction?
I'm going to turn to my statutory expert, Nate Wright, over here.
I'm gonna actually have to pull up, so that part wasn't changed by the law, so let me just pull up the only difference between this and swatting is that there has to actually be an emergency response, and the emergency response has to result in substantial bodily harm. So otherwise, it's the same as the gross misdemeanor. And the gross misdemeanor requires the intent, placing an emergency call, reporting a fictitious emergency with the intent of prompting an emergency response by law enforcement, fire, or EMS. So that's the intent, is that
Yeah, it's not to cause harm.
there's going to be an emergency response.
Commissioner Schnell?
Madam Chair, I'm compelled by the arguments of my colleagues here. I mean, because I do think, it's tough, but I hear, what Justice Moore and Judge Knudsen and Commissioner Latterstein, and that there is that distinction when I think about fleeing in comparison to this, that is a distinction that matters. So I would, just give a sense, despite my second, I would also be in a place where I would support the alternative.
I would as well on that one, because fleeing is at a greater risk, but then you gotta add there needs to be more facts of this for the fictitious emergency call, what happened and what was the basis of that? Did they intend that or did they not intend that? It's a big question, so, and fleeing a motor vehicle is, I believe should be at a more severe than, fictitious emergency call, so I'm willing to amend it into making this a 3 and then keeping that as a 4.
So you'd like to amend your motion to rank this crime at a level 3? And then, I don't know if the staff has other recommendations in there or not, but follow everything else, I would assume. Yeah, there's technical conforming changes that they recommended, so you want to keep those.
Making it a 3 on that one. Yes.
And Commissioner Snell is a second. Do you also
I would support
agree
that.
with that change? Okay.
Yes.
Any other discussion? Hearing none, as soon as Nate's able to finish
Sure.
drafting the motion,
Sure.
we can vote.
The Ibrahim motion to rank fictitious emergency call at severity level 3. To the Ibrahim motion to rank fictitious emergency call resulting in substantial bodily harm at severity level 3 and otherwise to adopt staff recommendations with respect to fictitious emergency calls. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes,
Knudsen, yes. Ladd?
Yes,
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
with that, the motion is approved unanimously.
All right, so the next crime is organized retail theft. This is a new crime. Very interesting crime. So it requires something called a retail theft enterprise, which is 2 or more folks who share a goal of shoplifting. And it doesn't have to be necessarily the same 2 people in every incident, but just that there be some kind of retail theft enterprise that the defendant is employed by or associated with. And the defendant has to commit a shoplifting related act within 6 months of 2 or more incidents of shoplifting, receiving shoplifting property, burglarizing a store, or possessing or shoplifting gear, or burglary or theft tools. So so basically this has got to be the 3rd incident within 6 months. And the 3rd incident has to be done while the person is employed by or associated with a retail theft enterprise. So it's much more advanced than just simply shoplifting. And the act that the person has to do is either, there does have to be shoplifting or receiving shoplifted merchandise or directing somebody else as part of the retail theft enterprise to shoplift. And that person or another retail theft enterprise member has to intend to resell or return the merchandise or advertise it for resale. So say put it up on Facebook Marketplace or something. So that's the crime. It's definitely much more advanced than simply shoplifting for resale, which is an earlier version of this crime that we had talked to you about. And the maximum, and there's a 6-month aggregation where the value can be aggregated. And if there's a risk of bodily harm, then it enhances to a felony. That's not very common. In the current theft statute. And it's added to the list of theft-related offenses. So Table 4 kind of lays out how this offense compares to theft, both in terms of statutory maximums and then rankings. So the far right column is the staff's recommended ranking. That is, the far right column here in Table 4 is written in sand. It's not at all binding on you. You can rank it whatever you like. So it's pretty simple. You'll get the pattern here on how the staff ranks it. So if the organized retail theft property value exceeds $5,000, if it were theft, that would be a 10-year felony, ranked at severity level 3. If it's organized retail theft, it's a 15-year felony, and we're recommending ranking it 1 higher at severity level 4. If it's between 1,000 and 5,000, it'd be a 5-year felony ranked at severity level 2. Organized retail theft would make it a 7-year felony ranked severity level, and we're recommending a ranking of severity level 3. Same if it's a value of 500 to 1,000 plus 2 or more convictions within the prior 10 years. That's a 5-year felony ranked at severity level 2 also, and we're also recommending a 7-year felony ranked at severity level 3. If it's below $1,000, then that would be a gross misdemeanor. It's going to be ranked at severity level 1 by our recommendation, a 2-year felony rather than a gross misdemeanor. If it's 500 or less, but there are 2 prior convictions, that would be a misdemeanor now. The statute would make that a 2-year felony, and we're recommending a ranking at severity level 1. So we're basically taking it 1 level higher than it is right now. And I think that's it. We're not recommending adding it to the offenses eligible for progressive consecutive sentencing or Section 8. So it's just these rankings that we're recommending, 4, 3, and 1.
All right, any discussion or motion? Commissioner Larkin?
I move to adopt staff's recommendation in full.
Okay, do we have a second? Commissioner Ladd seconds. Any discussion on the motion? Sounds like you made it easy for us, Nate. I think we're ready to vote.
All right, to the Larkin motion to adopt staff recommendations with respect to organized retail theft, Estrada? Estrada absent Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right.
All right, so the next offense is new burglary offenses, 3rd and 4th degree burglary offenses for shoplifting contrary to a trespass notice. So if someone, typically it'd be a shoplifter who's caught shoplifting in a store, it's a pretty common practice for the store's security personnel to issue that person a trespass notice, which makes it a crime if that person comes back to the store for a year. So trespass notices have a 1-year shelf life. Some jurisdictions apparently were prosecuting people who violated the trespass notice, came back to the store, and then shoplifted in the store. They were charging them with 3rd degree burglary, which is a felony. Now, normally 3rd degree burglary, you think it's somebody who's breaking into the store after hours or breaking into a part of the store that they don't have access to. This would be just walking into a store that's open to the public, in an area that's open to the public, but it's not open to you because you got a trespass notice. So the theory is you're committing a burglary. I didn't know that was something, but apparently it is a thing. We did the data analysis, and there are some jurisdictions that do that, some jurisdictions that don't. And according to the author of the bill, there's some jurisdictions that have like charging guidelines, so that they'll do that sometimes, and they won't do it other times. So the author of the bill's goal here was to make things uniform across the state. So if somebody does that, if somebody shoplifts contrary to a trespass notice, then that will become a 4th degree burglary, which is a gross misdemeanor, ordinarily. But if it's committed within 5 years of a previous felony theft-related offense, then that act is a 3rd degree burglary, which is a felony with a 5-year statutory maximum. So that's the bill in a nutshell. And the commission sort of took the very simple approach here of ranking the, so you don't have to make a ranking decision on the 4th degree burglary because that's a gross misdemeanor. The 3rd degree burglary, the commission just took the staff just took the very simple approach of recommending ranking that at severity level 4, which is how the existing 3rd degree burglary offense is now ranked. And otherwise just keeping the new 3rd degree burglary offense in every way the same as the existing 3rd degree burglary offense. In fact, that doesn't require any changes to the guidelines other than the fact that we think you can merge the words non and residential into one word. And that's really all you're doing there. So you could literally do nothing and this crime would be ranked at severity level 4.
A quick question. So we're not changing anything and the 3rd degree burglary in regards to the theft aspect. We're just changing the name or just combining the name.
Yeah, well, right. So the legislature, I mean, effectively by not doing anything, you're ranking the new crime at severity level 4. The new repeat burglary contrary to a trespass notice, or you know, it's, and we could break out those subdivisions if we wanted to, but if you treat it the same, we really don't have to. We could just say anything under subdivision 3. So now there's a 3A or 3.1, I can't remember, which is the old crime, and now there's a 3B or 2, which is the new crime. But there's no requirement to break those out if everything underneath is all ranked the same. If you wanted to rank the new crime at a different severity level, say at a severity level 3, then we would have to break those out, where the current non-residential burglary in the 3rd degree would be ranked at 4, and the new burglary contrary to shoplifting contrary to trespass notice, 2nd or subsequent, would be ranked at severity level X.
Commissioner Moore?
Madam Chair, Commissioner, or Director writes, what is possession of burglary tools ranked at from the guidelines standpoint?
It's pretty low. It's a 3. So
Just some food for thought on that. I was surprised to hear this charging posture because in my experience in the 5th district, maybe I wasn't being creative enough as county attorney, but
I wasn't either.
Me either.
these were not being charged in the 5th district. And this seems to me like, at the risk of sounding pejorative, kind of knocking someone down and kicking them for falling a little bit. I mean, I don't know. It has a feel to me of a little bit more like a burglary tool offense, frankly. But I'm not strongly opposed to it, but I don't know. Commissioner Middlebrook may have more experience seeing these cases come through. I have not.
So, Madam Chair, so I was in the same boat as you. I did not know that this was a thing. So our initial fiscal note, because I am involved in making the assumptions for the fiscal notes, came in at a prison bed impact that the author found high. So I got some pushback from the legislative staff on this because of the author's assumptions, which honestly I wasn't aware of until after the fiscal note was done. So we actually went back and looked at the data on these, and we did find, consistent with the author's testimony, that there were some jurisdictions where you'd get prosecuted for 3rd degree burglary for shoplifting contrary to a trespass notice, even though the store is wide open. And so we reduced the prison bed impact substantially because of that, because there was going to be some offset from those crimes that some crimes were going to move to felonies that were not felonies now, but other crimes were going to be moving from felonies to gross misdemeanors. So there was going to be a substantial offset because of that. And I think the author is probably right that this will create uniformity based on whatever the commission decides today. That will be how this crime is now treated.
Commissioner Middlebrook?
Thank you, Madam Chair. I would echo exactly what Justice Moore said, and I would say, based on what I've seen come through on these cases, there's very few counties that charge this as a Berg 3. There's very, very few of those. And what it seems that most of these cases are people who are homeless and mentally ill, and they keep getting the trespass notices and just as nuisance more than anything. And they're going in and they're, you know, a lot of times taking food, or they're taking things that they need. And it seems that I feel like severity level 4 is high to be locking up such people. Obviously, there's other fact situations, but again, because of the enhancement part of it, I don't see that it really fits the same as the regular, what we have right now as a 3rd-degree burglary. So I think that severity level 3 is more appropriate since we have to rank it.
That a motion?
I can make a motion that it should be ranked at severity level 3.
I will second that motion.
Okay, so Commissioner Middlebrook moves that we rank this as severity level 3, and Commissioner Moore seconds that. Is there anything, so you would have to make conforming changes to account for that too?
I'm going to put that in the motion, Madam Chair, if
Yeah.
that's okay.
With conforming changes?
Yes, absolutely.
Okay.
Yes.
So quick question.
Commissioner Ibrahim.
Would that change then 3rd-degree burglary by itself on a non-residential, say for instance, it's business and the business is closed at that time? Would that change it on the severity level to a 3 at that point then?
Not the existing,
Not the existing?
only
just-
this new one.
Okay, so this new one would change it to anytime it's a shoplifting, and you're trespassing to come back, that's a severity level 3. Okay.
Any other discussion?
Justice Moore.
Commissioner Moore?
Okay.
All right, any other discussion? Hearing none, let's go ahead and vote.
To the Middlebrook motion to rank burglary in the 3rd degree, shoplifting contrary to a trespass notice, 2nd or subsequent, at severity level 3, and to make conforming changes. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes. Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
and with that, the motion is approved unanimously.
All right. The next crime is, so there, right now it's a 5-year felony to possess, I think this is just a categorical ban. Machine guns, trigger activators, machine gun conversion kits, and short barreled shotguns. And the crime takes short barreled shotguns, which by the way are the lion's share of these offenses when they're committed. Take short barrel shotguns, carves that out separately, keeps that at the 5-year stat max, and quadruples the maximum penalty for machine guns, which is basically any weapon that you pull a trigger and bullets keep coming. It's a fully automatic weapon. Also, these trigger activators or machine gun conversion kits are included in that. These are devices that can convert, say, a semi-automatic weapon into an automatic weapon effectively. There are some clarifying definitions within the meaning of the term trigger activator that the bill also includes. But in staff's judgment, the crime is pretty much the same. It's just that the stat max is quadrupled. So staff's fiscal note, maybe we went on the heavy side in our assumptions, but we thought that the quadrupling of the statutory maximum penalty was a pretty firm legislative signal that the commission should treat this offense significantly more severely than is treated now. It's currently ranked at a severity level 3. So we hypothesized in our fiscal note that you might rank it at severity level 8, which is above the disposition line, even for first-time offenders. So that is a pretty significant ranking decision. And we submit that to you for your consideration.
Okay, discussion on this one. Commissioner
Madam
Middlebrooks?
Chair, I have just a couple questions.
Yep.
I didn't get the chart pulled up. What's the severity level for possession of a firearm?
Oh, like felon in possession?
Yeah.
Good question.
Is it 6?
6.
I think it's 6. I'll look. Yeah. You can look.
Yeah, it says severity level 6, Jill says, so
Okay.
take
And,
that to the bank.
and the second question, is there any reason why they left the possession of the short barrel shotgun? Do we have any answer on that? Why they left that one?
I just think there was quite a bit more concern about the dangerousness of in terms of mass casualties kind of thing, that could be
Okay.
caused by a
All
machine gun. And that was kind of staff's thinking in severity level 8 is that this could really be involved in a very, very serious, national news kind of event if this thing were used. I don't think that's true of the short barrel shotgun.
Other discussion, or does anyone want to bring a motion?
Just one kind of
Commissioner
question,
Schnell?
so, because I think I'm just trying to get a sense here. A possession of a firearm by an ineligible person is 6.
With a mandatory minimum, I should add.
With a
So,
mandatory
This
minimum.
does not have a mandatory.
Yep. And so I'm trying to get, the distinction then is, this would be a presumptive commit. You could, it's, when you look at like mass casualty event versus somebody who's in possession of a firearm that has been modified with a sear switch. I mean, I'm not trying to minimize the significance of it, but it does change, substantively change what happens. It's an interesting because the distinction, simple possession, especially when, these things are like all over the place in the internet. There's reason to be deeply concerned about them. I'm just trying to kind of talk through my own thinking on this.
I'll
Commissioner
say
Middlebrooks?
this, if you,
Oh, and
sorry.
I'm sorry, go ahead, Commissioner Ibrahim, go ahead.
you have the possession of a firearm just alone, and you're a felon in possession, and that's a 6. But then now you're a felon in possession of a firearm, and you have a switch on it, which is, what do they call it? The trigger activator. So now that causes that firearm to be significantly different in that possession. Whoever is in possession of that firearm, even if it's an ineligible person, that creates a higher risk. So I do believe that should be categorized at a higher level than the just ineligible, and a person ineligible of just carrying a firearm.
Okay, Middlebrook, then Larkin, then Ladd.
I have a question, on the fiscal note, I see what the impact was. Do you have any data on how many of these crimes there were?
We did in the fiscal note. I'd have to pull it up. I mean, they were almost all, like all but 1 or 2 were short barrel shotguns. And then the ones that were not were these auto sear devices, which I think would qualify as either a trigger activator or whatever the other.
Or a switch, they call it.
Yeah, so we saw some of those, but very small number compared, so I want to say it was 2 cases within maybe 3 or 5 year look back period. I don't recall how far back we went, but
Okay, so then we are down to Commissioner Larkin, then we'll do Ladd, then Moore.
Okay, thank you. So here are my thoughts, and I want to make sure I'm understanding this law, because there's been a lot or several statements saying, well, felon in possession. And I think under this new law, it applies to everyone. In other words, someone who's never been arrested for anything, doesn't have a parking ticket, goes on the internet, sees that these parts are for sale and buys one, they've now committed a crime with a presumptive prison commitment. Am I correct? And if so, that concerns me. And I think maybe another thing we could look at doing is raising it to a 7. So there is a distinction between the short barreled shotgun and the other items, but it's not an automatic prison commitment. Because I am concerned by what Commissioner Schnell said, that these parts are readily available on the internet. I can imagine somebody going, well, it's on the internet, it must be legal. And all of a sudden they've made a purchase that puts them in prison. So that is a little concerning to me.
and I think a bump stock, I don't know if this adds to the equation, but I think a bump stock is literally a piece of plastic that uses your finger as in connection with the recoil to simulate an automatic weapon. So you could print that off on a 3D printer. You don't even have to go out of the state to buy it. But it is.
How do you know this, Lee?
So when I heard the recording of the Las Vegas massacre, I literally thought that was a fully automatic weapon. I hadn't heard of a bump stock. So I researched that afterwards. So that bump stock converted that person's semi-automatic weapons into automatic weapons.
Commissioner Ladd.
Thank you. So I will just say that I am concerned about sort of what I would say is the signal when you talk about a quadruple statutory max penalty. I mean, that's a pretty big, that isn't even a little flag being waved. That is a bright light beacon saying, something needs to change here. And one of the thing I want to be clear on the record here is that I know that the felon in possession of a firearm, or the ineligible person in possession of a firearm, is a severity level 6, which is typically with little or no criminal history is a presumed stay, but it's always a mandatory minimum of the 60 months. So that offense, even though it's ranked at a 6, the consequence for that would be 12 months longer than the middle of the box for a severity level 8 offense, which is with 0 points on it. And you indicated that there's not a mandatory minimum with this particular statute. So I just want to be clear that I know that when we're talking about 6, there's an added piece of the mandatory minimum that triggers it. So it kind of has its own little special category that way. So we're always talking about prison unless there's a departure with those ineligible people having any kind of firearm regardless. So, but I think this is obviously a huge public safety issue, a public safety concern. And I think that's perhaps why the signal here for the maximum penalty, they split it out. And then just the one other clarification I wanted to understand is because they parsed this out, we aren't having to address the short barrel shotgun piece. It's only this one is what we have to wrangle with. Is that correct?
Correct.
Okay. That's all I had to say. Thank you.
Commissioner Moore.
Thank you, Madam Chair. Well, Commissioner Ladd sort of echoed or stole my thunder on the
Sorry.
legislative signal. I think it's kind of a blinking red light, obvious, humongous public safety concerns regarding these devices and the potential for just mass casualty mayhem events. Director Wrights, I was wondering, was the felon in possession charge or an eligible person in possession charge amended to include any reference to machine guns or any of these trigger activator devices or anything like that? I mean, was there anything done to that statute that tracks this in any way?
I'm sure, no changes.
All right. Well, I I mean, I would support staff's recommendation, assuming staff's recommendation is that it be ranked at severity level 8. I would make that motion.
I'd second that.
And then, so Commissioner Moore makes the motion to follow staff recommendations, Commissioner Ibrahim seconds. Any, and is that for all of the recommendations?
It is for all the recommendations related to, I guess, this machine gun trigger activator conversion kit issue.
All right, any discussion on the motion? Anyone?
I don't know that right off the top of my head. Could we ask a question?
Yeah, of course, Commissioner Lack.
What is the statutory max for an eligible person with a firearm? I was gonna try to find it real fast, but I'm not getting to that fast. What the statutory references?
Right. It is by 15
And 30? No.
15-year, $30,000.
Thank you.
Any other discussion? Okay, hearing that, I think whenever you're ready, we can go ahead and vote on that one.
Okay, so to the Moore motion to adopt the staff recommendations with respect to 609.67 subdivision 2, including ranking machine gun trigger activator or conversion kit at severity level 8. Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
and with that, the motion is approved unanimously. Would people indulge me in a 5 to 10 minute break?
Comfort break
A
perhaps?
comfort break would be lovely. How about we take how much time do you want? 5 minutes or 10 minutes?
5 to 7 minutes.
7, we're gonna, what's the difference? We'll be back at
Of course.
I've never seen a
3:17.
district court 5-minute break. I've never seen that.
Pronounce it.
I know, we say it.
Just don't.
I guess it doesn't, so you can start.
And,
All right, we're gonna go ahead and resume our business today. We're coming calling us back into order, and we will continue with our ranking exercises. Go ahead, Nate. Guess we're on, is it interference with privacy we're on now?
Yes, so this will be interesting. So,
That's a good way.
all right. I'm just going to start with this table that I mentioned at the very beginning. So this is how the interference with the privacy statute is laid out. There are 2 new offenses, and this has to do with a Supreme Court case that,
Sorry.
no, I honestly, so it overruled a Court of Appeals case that had been around for a long time that said, when the legislature said window or aperture, they were including a camera's aperture in there, which was always or for that matter, an aperture of a dress. So it was always a little bit suspicious whether it was really valid, but the Supreme Court took a look at it and recently and said no. So the legislature pretty quickly responded by making it a separate crime, essentially making the camera's aperture good enough. So here's how the offense is laid out now. I'm just going to go through the list, and hopefully this will give you an idea of where it might be appropriate to rank. So all offenses, their base severity level is a gross misdemeanor, except for this new offense of surreptitious photography under or around clothing, which I think probably covers that Court of Appeals case regarding, if the aperture is a dress. that qualifies. And I think the legislature is maybe preemptively acting in case of say, somebody surreptitiously taking a photograph of people's dresses is a thing, I understand. So that's covered as a misdemeanor now, surreptitious photography under or around clothing. So whether you're either taking pictures of somebody's private parts or the clothing immediately covering the private parts. So so just starting from the top. So your basic peeping Tom looking through a house window is a gross misdemeanor. Surreptitious observation device, the same crime with a house, but in this case, using some kind of recording device or video device, such as a camera. And then 1C is another private place, just looking. And then 1D is using an observation device, such as a camera, to look through another private place. And those are places like locker rooms or tanning beds, or other places where you might have a reasonable expectation of privacy for 1C and 1D. So you got house for 1A, other places where you'd have an expectation of privacy, 1C, 1D, places where you might expect somebody to be getting undressed, for example. And then 1E this is the new one that surreptitious photography. It doesn't split out houses versus other places where you have an expectation of privacy. It's all lumped together in 1E, also a gross misdemeanor to photograph somebody. So it's very specific to photography. And then 1F is surreptitious photography under or around clothing. Probably covering that upskirting, like I was saying before. So 1E is a gross misdemeanor, like most of the other offenses. As I said, 1F is a misdemeanor. So then we get to the felony enhancements, which is where we come in. So if any of these offenses are either there's a prior interference with privacy conviction or prior harassment or stalking conviction. So those are the related convictions that we're talking about. If there's one of those prior convictions, then it becomes a felony. Any of the gross misdemeanors become a felony, which the commission has ranked all those at severity level 1. And since this new gross misdemeanor also fits into that felony, the 2-year felony enhancement scheme, we're recommending ranking the 2-year felony for that offense also at severity level 1. The misdemeanor is going to be ranked, is going to be elevated to a gross misdemeanor if there's a prior related conviction. So that 2-year felony enhancement also applies if the victim is a minor. So either there's a prior related conviction or the victim is a minor, it's going to be the 2-year felony, which you've ranked it at severity level 1. Interestingly, this offense is not listed in section 6, which is the offenses eligible for permissive consecutive sentences. So this offense was created in the same year that the list of offenses eligible for permissive consecutive sentences was created. So it used to be that it was just a crime against a person that could be sentenced consecutively, but then Blakely came out and there were some concerns that, are we going to have juries find that this is a crime against a person or not? So the commission said, why don't we just make a list of crimes against the person in section 6 and we'll just cover it that way. So they did that. The same year, this felony enhancement for interference with privacy was created, this 2-year felony. And the commission voted not to add this offense to the list. So we'll talk about that later. So then there's another enhancement of more recent vintage. This is the 4-year enhancement. So where it's against a minor with sexual intent. And this applies to most of the gross misdemeanors, but not all of them. So it doesn't apply to just regular peeping Tom offenses where somebody's just looking with an eyeball through a window or other aperture, I guess. But it does apply if there's a surreptitious observation device or a camera. So if there's a surreptitious observation device or a camera, it becomes a 4-year felony if 2 things are true. 1 is the victim is a minor, and 2 is it's done with sexual intent. I want to say that the facts of the case that sort of spurred this had to do maybe with a stepfather photographing his stepdaughter or something like that in the bathroom.
Oh,
So,
no, I looked this up last
oh,
night.
oh, really? Okay,
It was a coach
Coach.
filming kids in the locker room.
okay, thanks.
Yeah.
All right, so the commission hooked on to the fact that, so this was a more recent, this was actually during my time, so sometime, when was, you looked it up, so you
It
said-
was enacted in 2019, but it was actually heard in 2017 and 2018.
Okay, so the commission ranked this on the sex offender grid as a sex offense. It's severity level G. And that's obviously because there was sexual intent as an element of the crime. So it had to have sexual intent. So the commission felt like it was appropriate to call that a sex offense. So that's and that enhancement also applies to this new surreptitious photography. So if somebody's photographing someone, actually it probably would apply to that coach situation that you're talking about. So the coach situation under the recent Supreme Court case might, depending on the facts, might not have fit under this offense anymore. But it would fit under the new subdivision 1E, the surreptitious photography. So that's also included along with the other surreptitious observation devices under the 4-year felony. Staff's recommendation also ranked that at severity level G. Finally, we get to the new 5-year felony enhancement, which only applies to this surreptitious photography under or around clothing. Recall that that offense already gets enhanced to a gross misdemeanor if there's a prior related conviction against a minor. But if you got 2 prior related convictions, so this is your 3rd time either harassing somebody, stalking somebody, or interfering with somebody's privacy, then it's a 5-year felony. And staff's recommendation is to rank that at severity level 4. The reasoning there is that the looking at other crimes where there was a misdemeanor enhanced to a felony because of 2 prior related convictions. And that sort of reminded me of the sentencing scheme that we see for a lot of qualified domestic violence related offenses. Those could be assault, domestic assault, OFP violations, HRO violations, where the first time it's a misdemeanor, second time it's a gross misdemeanor, third time it's a felony. So those the commission ranks at severity level 4. So staff thought, well, maybe this should be a severity level 4 as well. So then we get to offenses eligible for permissive consecutive sentences that list in section 6. We do recommend ranking the new 5-year felony in section 6, although that might deviate a little bit from my status quo bias, because right now this offense is not ranked at severity level 6. I list a few arguments there why you might rank it in severity level 6 while still not keeping the other offenses on severity level 6. Frankly, I find it a little odd that the other offenses aren't on severity in section 6. Sorry if I said severity level 6. They all seem like they're crimes against person to me, but yet the commission affirmatively chose not to put it on section 6 when it created section 6. So I guess there's certainly argument to be made to the contrary to not put the new 5-year felony in section 6, but that's what I was recommending. So I think that concludes our recommendations, Madam Chair.
Okay. Discussion on this issue.
Madam Chair, I should say there are these offenses were renumbered in some way, so they pushed some of the clauses down. So there are a number of conforming changes that need to be made as well.
I think I'm gonna suggest that we might want to tackle ranking first and then consecutive sentence list second. Maybe we should tackle those separately on this one. If everyone's good with that.
Just a quick question.
Commissioner Knudsen?
We're bouncing around between severity level 1 and severity level G. So we're bouncing between grids, it appears to me, can I get a better explanation as to why some are on the regular sentencing guideline grade ones, and then some of the offenses are on sex offender?
I think it's just because that one offense has an explicit element of sexual intent. So the others might just have, I don't know, be motivated by mischief or who knows what. But to be guilty of the severity level G offense, it must be proven beyond a reasonable doubt that the defendant acted with sexual intent against a child. So that the commission felt was sufficient, and that element is absent from any other part of the statute.
And it's also not defined anywhere as to what that means, minor, against a minor with sexual intent. I went in search of that last night, and I watched the original testimony when the bill was developed. And there was actually frank discussion about how this language that's borrowed from the stalking statute and brought into the statute, but in the hearing, no one seemed to know what it meant either at that point. However, the case that spurred this was the coach filming in the locker room and then watching those films for his own sexual gratification. So they all seem to accept that as what this is intended to get at. I don't know if it's been used in other ways since then, because it's been 4 years, but that might be why the commission also put it on the sex grid at the time. I don't know.
Madam Chair.
Commissioner Schnell.
So I'm going to just think out loud here for a minute. Because your question is spot on, because what am I not getting here? And I think, but I'm struggling just to understand this in terms of the context of mischief versus, I think about, and again, I'm drawing other things into this, but I even think about things like the ECRC process, and we have people who have had level 3 designations when there have been like perpetual offending around this type of a crime. And so I'm just trying to wrap my head around like what, that distinction of what would the facts look like. I mean, I understand where somebody could say, well, I'm just joking around. And it still has some consequences, and there's the misdemeanor level offense, but when does it not, and is it something other than, by way of the conduct, something with some level of sexual intent? Not that it's a requirement that we prove that be proved, but I'm just trying to wrap my head around that by way of thinking about where this sits and why there's a distinction around. I get it's rational what you're describing, Nate, but having the other offenses on the other grid doesn't seem to make a ton of sense.
So the irrational part is not ranking everything on the sex offender grid? Is that what you're saying?
Yeah, like where does this not look like it has kind of a nexus to some level of sexual intent when you start looking at repeat offenses.
Commissioner Morath.
And I have been racking my brain trying to wrap my head around this too. And for me, it's really comparing, when I read it, to me, what is the line between child pornography and the intent, or it being interference with privacy? That line is very, very blurry to me, and I don't know what that distinction is. Go ahead, Nate.
So here's a comment that may be inappropriate, Madam Chair, and I apologize if it is, but so the commission's authority to make a ranking decision without pre-submitting it to the legislature or to make a change to the guidelines, any change to the guidelines without submitting it to the legislature, it applies if the crime is created or amended by the legislature in the preceding session. So arguably, by making any change to the interference with the privacy statute, the legislature made it fair game for you to make any change you want. So I suppose you could rank all these offenses on the sex offender grid if you wanted to, and arguably, I think that might be in the letter of the law. Maybe others would have a different opinion on that, but it is written fairly broadly, your authority to make guidelines changes if the crime has been created or amended.
Madam Chair,
Commissioner.
I don't want to be clear, I'm not advocating that, I'm just trying to wrap my head around the distinctions.
Commissioner Middlebrook?
Thank you, Madam Chair. I don't know if I can clarify that at all, but the one provision that was existing that the commission ranked on the sex offender grid has to do with the violation of the statute, these different subdivisions that involves a minor, and there's also the element that it's done with sexual intent. So I think that was why that particular felony got put on the sex offender grid, because of that extra element. And the other subdivision, all the other subdivision parens before the new law didn't have that extra element in it. So, obviously there's a big range of behavior, but it didn't have that extra element. The change here for the new laws really brought in the camera, the photographs, but it's still, to answer the question about why it's not child pornography, if you look at the definition of child pornography, those have to depict an actual or simulated sexual conduct, like using them in a sexual performance. This is focused on the invasion of privacy and the devices that are used to invade the privacy. Obviously, if it went the next step and there was any recording or pictures of the sexual conduct and it was either, possessed or posted somewhere, it would move it into the child pornography if it was of a minor. But this is kind of, I look at it sort of as a step before that, and obviously the child pornography possession and dissemination is way more serious. But I think it does seem a little odd that one's on the sex offender grid, but the others aren't, unless you look at that specific element has to do with the sexual intent. I don't know if that's helpful.
I think that is.
Commissioner Mara? So with the case of the coach then, wouldn't that not apply if this is one step before? Because in that case, it did produce recordings, right?
Well, I think that it would fall into the felony for D or E, because it was against a minor with sexual intent. So the D is the device,
Right.
having the device and recording a minor with sexual intent.
Maybe I'm misunderstanding what you were.
Yeah, I don't know, that case, did you say that went back to 2019? It's when the first 4-year felony that was put on the sex offender grid.
Yeah.
That's when they enacted that,
Okay.
because otherwise it was just the gross misdemeanor or
Right.
misdemeanor, and that they were trying to get at that behavior where there was the minor involved with some sexual intent.
Right.
So that's where that first 4-year felony came in. Is that right, Nate?
Yes, Madam Chair.
Go ahead.
And to be clear, we did a comprehensive review of child pornography, and we learned that there is a category of child pornography that's people surreptitiously recording people in certain circumstances. So I mean, if the elements of child pornography are met, certainly that could create child pornography, and then the person would be certainly moving to the sex offender grid.
I think for me, 1E, the suggested rankings for 1E are consistent with the way that all the other elements of this crime are currently ranked. And I don't really have a problem with following that ranking. For 1F, I'm just not, I guess I'm a little, I don't know if the felony is ranked, if the suggested ranking for the felony is right, because there's no sexual intent in the elements of the crime. And it's two prior related, right? Two prior related rather than one prior related. So it's kind of weird because the legislature is saying it's less severe by putting that one prior related at the gross misdemeanor level. And then putting two up at the felony level. I don't know, jumping up to 4 feels a little high compared to the first time offenses that we have for all the other versions of this, especially given the type, the signals the legislature is sending with that first prior being a gross. So I don't know if that should be maybe a 3 instead of a 4 or a 2. I don't know. Commissioner Ladd.
Thank you. So on that point, I think I thought about it similarly to how Nate explained it, in that, you have a misdemeanor assault, then you have a second misdemeanor assault becomes a gross misdemeanor, and then you have a third misdemeanor assault that becomes a felony. That's a severity level 4 offense. So I see that sort of that graduation of that very similar to that. And sort of the bootstrapping of those prior offenses. And so I'm just trying to think like what other offenses we have that there are 2 predicated priors that we would rank at a severity level 3. Do we have any such offenses that are like that?
Well, I think, you can answer that in a minute, and then I'll respond. I think what I'm reacting to is, if you look at all the rest of them, there is a misdemeanor, gross misdemeanor version of those crimes too. But then when they go to a felony, it's a 2-year stat max, and we're ranking it at a 1. The only reason the stat max on this one is a 5 is because the legislature was silent on what the stat max was. They didn't say. So it's the default. So I think they messed up there. And so it's like we might be overweighting it by taking it up to a 5. So then if somebody now look at A through E, if someone commits that again, let's say they've already done their 2-year felony, and then they do it again, they're just moving over a box, on our grid. So then they're still not getting up to the same penalty that this first-time felony, on surreptitious photography would get up to. So that's where it feels disproportionate to me, and I'm just not sure how to bring that into line. And the other behavior feels more serious to me than that one too. So then that's why I struggle with where to put this one.
So purposes of this, if I can,
Commissioner, yeah.
I would move that we adopt recommendations of staff with the exception of 1F being put at severity level 3.
Okay. Do we have a second for that? Commissioner Moran, seconds? Okay. All right, any discussion? Everybody clear on the motion? Want to make sure before we move on. Okay. All All right, I think we're ready to vote when you are, Nate.
To the Schnell motion to adopt staff recommendations with respect to interference with privacy, except ranking violations of subdivision, felony violations of subdivision 1F at severity level 3. Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes,
Knudsen, yes. Ladd?
No,
Ladd, no. Larkin?
No,
I think you might have been muted.
Larkin?
no,
Larkin, no. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, 2 votes opposed.
Okay, with that, the motion is approved. So then that just leaves the consecutive sentencing decision. So remind us what your recommendation was on this
Well,
one.
I mean, I'm not necessarily, I can't really give a really good rationale for this, other than this just doesn't seem like, this seems like it's a crime against the person. I don't know how you view it as not being a crime against the person. Like upskirt photography, third time you've done it. I mean, it just seems like it's or you've done something like it. It seems like it should be considered to be a crime against the person to me, but it's not really consistent with how other interference with privacy offenses are termed. I did list a few arguments why this might be different, but to be candid, I think the biggest reason is it just doesn't seem like it's not a crime against the person to me.
Okay, and so just to clarify, are any of these, Frank, on section 6 right now? Are any of these on the list
Let's
right
see.
now?
Why do I not know that? Let me see.
I apologize for
No, that's fine. That's an
having
excellent
that
question.
clear.
The severity level G is, no, I'm sorry, that's appendix 3. That's, yeah, that's right. So the severity level G, all sex offenses are on the list. So it would be inconsistent not to have it on the list. So the minor victim and sexual intent is listed in section 6.
Okay, so for 1B and D, which have a severity level G now, those versions are on the consecutive, presumptions of consecutive list.
True.
And so it would be consistent to put 1E on there, is one thing I hear you saying.
Yes,
But then were you also recommending 1F?
yes.
Okay,
So putting both of the new felonies on. Well, not the 2-year. I wasn't advocating putting the 2-year felony because that would be
just the 4-year, the 4-year.
just the
version.
4-year and the 5-year felony.
4-year and the 5-year. Okay, Commissioner Moore.
I would move that we adopt the staff recommendation to make the 4 and 5-year felonies to be added to section 6 as recommended.
Both of them?
Yes.
Okay, and do we have a second? Commissioner Knudsen?
Second.
Seconding? Okay, discussion on the motion? Okay, I'll take it then. I would support putting 1E, the 4-year felony that we have ranked, that we have just ranked as severity level G on the consecutive list, because I think that's consistent with how we have treated the other like offenses. But the 5-year felony does not have the element of intent against a minor with sexual intent. So I think that's different, and for the same reason that we ranked it lower than the staff recommendations. I think it's just a less serious version of that offense, and I don't think it should be on the consecutive list. Any other discussion? Okay, I'm not hearing any discussion, so we'll go ahead and vote on that.
To the Moore motion to place the new 4 and 5-year felonies for interference with privacy on the list of offenses eligible for permissive consecutive sentences. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
No.
Middlebrook, no. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
No.
Chair Mitchell, no. Madam Chair, there are 7 votes in favor, 2 votes opposed.
And with that, the motion is approved.
Right.
And that's it. We don't have to do anything else on that one, right?
No, we're done with that. Number 7. So number 8 is, it's an existing crime. It's a gross misdemeanor, making a false statement to obtain a firearm transferee permit. So this law, Chapter 13, creates it expands the requirement to do background checks for firearm transfers. And as part of that, it increases the penalty for lying on a firearm transferee permit application. So I've listed here the information that a person applying for a firearm transferee permit must provide to law enforcement. And the reason I list that is because for this crime to occur, something on that list must be false. It could be, eye color. It could be whether you're prohibited by statute from possessing a pistol or semi-automatic military-style assault weapon. If you make that false statement and you know or have reason to know that the statement is false, then you are guilty of a gross misdemeanor in current law and a 5-year default statutory maximum felony under beginning August 1st. Candidly, thought this was kind of a tricky ranking decision here. There's a number of sort of analogous crimes that you might look at. We recommended severity level 1 because there were quite a few, lying on an application for a vehicle title, for a bill of lading, lying on a bill of lading, false declaration on a public assistance application, false certification by a notary public. Commissions ranked all those at severity level 1, so that was our recommendation. Alternatively, you could leave it unranked because it's probably not going to happen that often, or maybe it will, I don't know. Or you could rank it at a higher felony level, or severity level. So 2 candidates are severity level 4 and severity level 5. Severity level 4 is where perjury is. A really interesting one is severity level 5, which is perjury felony trial. So that's what the guidelines call it, perjury felony trial. But also under the same subdivision, subdivision 4(1), it's a 7-year felony. In addition to covering felony trials, that clause also applies to a false statement upon an application for an explosive license or use permit. And I don't even know if the commission was thinking about that when it ranked it at severity level 5, because it calls it perjury felony trial. But it does appear that severity level 5 ranking applies to that. And there are arguably some pretty strong similarities between an application for an explosive license or use permit and the crime at issue. Although, maybe an explosive, does broader damage than a firearm is likely to, and an explosive, you're actually going to use it, and maybe a firearm you're not, you're just keeping it around for safekeeping or, in case of emergency. So we're sticking to our severity level 1 recommendation, but you could make an argument for other recommendations. And we're not making any recommendations for changes to section 6 or section 8.
Great. Commissioner Middlebrook?
I would move to adopt staff's recommendation.
Okay, is there a second?
Second.
Commissioner Schnell seconds. Any discussion on the motion?
I'm sure just one observation. Somebody lying about their weight, just as somebody who has struggled here, I would just say that that's pretty.
Yeah, a little concerned about that. Well, for me, it might be height.
Oh, the height.
All right, we'll try to give you a departure if you do that. All right, any other discussion? All right, hearing none, we'll go ahead and take a vote on that.
And just point out, you have to know or have reason to know. So, I mean, if you haven't been on the scale in a long time, it could be a defense. All right, so to the Middlebrook motion to adopt staff recommendation to rank false statement to obtain firearm or transfer permit at severity level 1. Estrada absent. Ibrahim,
Yes.
yes. Knutson,
Yes.
Knutson, yes. Ladd,
Yes.
yes. Larkin,
Yes.
Larkin, yes. Middlebrook,
Yes.
Middlebrook, yes. Moore,
Yes.
Moore, yes. Morath,
Yes.
Morath, yes. Schnell,
Yes.
Schnell, yes. Chair Mitchell,
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
and with that, it passes unanimously. Before you get started on the next one, I just want to congratulate you on finding a crime in the Omnibus Commerce Act, because it means you really kept an eye on things this session.
So I'll tell you what, Madam Chair, I think, well, I think I sent you the draft the night before, and I don't think this was in it, because I did not know it was there. And I did a full text search of all bills that were enacted in the session, and I found this. If this made it in front of a crime committee, I didn't notice it. But here it is, money transmitter regulations. I don't really know what a money transmitter is, to be honest, but there's a chapter of law right now that, chapter 53B that covers money transmitters, and it doesn't repeal chapter 53B, but it repeals every section that's within chapter 53B, and it replaces it with a whole new chapter 53B essentially. And that regulates money transmitters. Right now, there are no crimes in chapter 53B, but there will be a crime for either intentionally making a false statement, misrepresentation, false certification, false entry, or material omission in a record filed or required to be maintained under that chapter, or knowingly engaging in an unlicensed activity under chapter 53B, and for that activity receiving more than $1,000 compensation within 30 days. So there's a very, very similar provision in 62A.41, which establishes very similar criminal penalties for violating regulations concerning accident and health insurers and insurance agents. That offense is ranked at severity level 1. Thinking about just recommending you leave it unranked, but it really does seem like an analogous offense. So we're recommending calling this crime money transmitter regulations and ranking it at severity level 1 and not changing any of the lists.
All right, does anyone want to make that motion?
I'm sure I'd move it.
Commissioner Shell
As
makes that
recommended.
motion,
I'll second it.
and Commissioner Ibrahim seconds. Any discussion on the motion?
Right, to the,
Nobody is going to demonstrate their hidden knowledge of money transmission. Had a lot of hidden knowledge come out in this meeting already. So I just want to make sure.
so to the Schnell motion to rank money transmitter regulations at severity level 1 as recommended by staff. Estrada absent. Ibrahim,
Yes.
Ibrahim, yes. Knutson,
Yes.
Knutson, yes. Ladd,
Yes.
Ladd, yes. Larkin,
Yes.
Larkin, yes. Middlebrook,
Yes.
Middlebrook, yes. Moore,
Yes.
Moore, yes. Morath,
Yes.
Morath, yes. Schnell,
Yes.
Schnell, yes. Chair Mitchell,
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
and That is approved unanimously.
Okay, so this one we were tracking, deepfake technology. There's two crimes, and I don't know why, but I listed them out of order here. Maybe
Might have been tired by then.
well, I think I started with a more interesting one. So deepfake technology, deepfake is a technically produced image, video recording, or audio recording that's so realistic that a reasonable person would believe it depicts the speech or conduct of an individual who didn't, in fact, engage in the speech or conduct. And maybe you've seen these floating around on the internet where you'll see a celebrity or a politician making a speech that that person would obviously never actually say. And it looks pretty convincing, and I'm sure as time goes on, it's only going to get more so. So the first crime is use of deepfake technology to influence an election. The second crime, though, is the first one we're going to discuss, which is non-consensual dissemination of a deepfake depicting intimate parts or sexual acts. And this crime is really modeled after a crime you may recall discussing just a few years ago, a revenge porn statute, non-consensual dissemination of private sexual images, where there's kind of a gap in the law where somebody who distributed maybe consensually gained images that depicted somebody's private sexual parts or conduct would display those publicly without consent. And the seven factors that apply to make this a felony also apply to the revenge porn statute. So it's really almost the same. It really is the same structure of the crime. It's just this applies to instead of actual images of private sexual parts or conduct, this applies to deepfake images that depict intimate parts or sexual acts. Like the revenge porn statute, the crime is generally a gross misdemeanor, but it becomes a 3-year felony when any of the following 7 factors are present. And those essentially have a theme of essentially publicizing it or benefiting from it or getting the deepfake by some untoward means or having a previous conviction. So we, not overthinking this, we recommend just ranking it the same as revenge porn, which is severity level 3, and adding it to the offenses eligible for missing consecutive sentencing.
Madam Chair.
Commissioner Led.
Could I just pick on somebody who's been here a while historically? So I'm just wondering why when the prior commission ranked the revenge porn and put it on the regular guidelines versus on the sex offender grid, the component of that, was there some reason for that distinction?
I do not recall, and I don't know if you do.
I mean,
I don't even know if I was here.
yeah, it doesn't necessarily have an element of like a sexual intent kind of element. Like you might be doing it just to be mean, or be spiteful, or to be getting back at somebody for like kind of, as the name implies, revenge, for breaking up or something like that. I mean, it doesn't.
Well, that's not what it's actually called in the statute.
No, I know it's not what it's called in the statute, but that's what everybody called
Yeah.
it as they were making the bill. And so, I mean, I think the commission's been pretty careful about requiring that the person have, I know it's called sex offense, it is called the sex offender grid, right? So the person who commits it really has to have some kind of sexual motivation, and it's not necessarily true just because what they're dealing with is sexual in nature, that the person's intent is sexual. The person's intent is very well maybe, and arguably probably is motivated by a damaged relationship that they won't want to avenge.
Thank you.
Madam Chair.
Commissioner
I
Schnell.
would move adoption of the recommendation just based on the simple fact that I don't know that the harm is fundamentally different, whether it's, deep fake or it's an actual harm is the consideration.
Okay, so Commissioner Schnell moves to adopt the staff recommendations. Do we have a second?
Second.
Commissioner Knudsen seconds. Any discussion on the motion? not seeing any, so we'll go ahead and vote.
To the Schnell motion to rank non-consensual dissemination of a deep fake depicting intimate parts or sexual acts at severity level 3 and to place that offense in section 6 as recommended by staff. Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously.
Right. So, Madam Chair, this is, the second one is using deepfake technology to influence an election. We don't see a lot of violations of the felony election laws, but maybe this will be an exception. So the crime occurs when someone within 90 days before an election disseminates or contracts to disseminate a deepfake, knowing or having reason to know the item is a deepfake without the consent of the depicted individual and with the intent to injure a candidate or influence an election result. So it's actually a misdemeanor, becomes a gross misdemeanor when convicted committed within 5 years of one or more prior convictions, and a felony if the 5-year stat max if committed within 5 years of. Oh, I'm sorry. It's a gross misdemeanor committed with intent to cause violence or bodily harm. I'm sorry. And if it's one prior, then it's a felony, 5-year felony. So, and here's where we list the unranked offense possibilities. So we're recommending leaving this offense unranked. There have been no convictions for prohibitions against false political and campaign material in the past 5 years. We're not expecting this to occur with a greater frequency. Or you may want to rank it at severity level 1 along with other voting violations which have a 5-year stat max.
Any discussions on this one? Commissioner Middlebrook?
Thank you, Madam Chair. I would move to follow staff recommendation to leave it unranked and kind of see what happens if there are any, since there are no convictions under this so far.
Do we need a motion? Do you want a motion if we leave it unranked or?
I think so.
Okay, I just want to make sure that I was following procedure. All right, so Commissioner Middlebrook moves to leave it unranked. Do we have a second?
I'll second that.
Commissioner Ibrahim seconds. Any discussion?
Can I just ask a question?
Commissioner Schnell and then Commissioner Larkin.
I just am wondering about just the distinction given some of the broader dynamics that we have seen. Again, the changes in technology and that kind of stuff. I'm not super strong feelings, but I just wonder about the fact that having not ever run for an office, it seems like it would be considerably harmful, and yet in today's world and the access to different types of technology, it seems like it's something that could be more readily done, easy to do. And I raise that as a question. That said, I also recognize that we haven't had that here, at least that we're aware of, but I think certainly we've been hearing a lot about it at the national level, and even allegedly by non-state actors or other states actors, and so I don't know. I just raised that as an observation given the changes in technology.
Commissioner Larkin?
We can't hear you. I think she's speaking.
I'm so sorry. Why not put it at level 1 where other similar offenses are ranked? What do we think is so different about this that would justify leaving it open for a higher ranking? And that's not to be argumentative. I just wonder if people have a sense.
Go ahead, Commissioner.
I would just try to answer it and say, like, because the offense is really prosecuted, and if it's new and the severity of a typical offense cannot yet be determined, it would be the factors that we look at apparently, but if it's between unranked and severity level 1, I would assume that that's where the kind of the default would be anyway. I think that if that would be the argument, well, it's a felony, so we have to assume it's at least a severity level 1. But I agree with the commissioner. I think we're going to see some of this. There's campaigns are pretty creative, and they're going to start doing this kind of stuff. But there is the possibility of this felony level offense, and not knowing where it's ranked. I mean, what impact does it have? Not knowing where it's if it's unranked or if it's severity level 1. I just don't know what the which way we would go to influence what. I don't know.
I'll say that what I struggle with is clause 3. I actually pulled up the language. So clause 3 is, so you have to do this with intent to injure a candidate or influence the result of an election. And I see that as a broad range of behavior. So influence the result of election, like if we play out facts, maybe that's like making it appear as if a candidate said something that would cause people to vote against them, so they lose the election, right? That's it's not injuring them other than that they lose the election, right? But the other one, intent to injure a candidate, could be doing something that causes people to act in a vigilante type manner and actually injure that candidate. And that's a huge range of behavior. So I don't know where, like, I think as a judge, you might put those in different places. As a commission, I'm not sure how to think about the type of facts that could fall under this. So that's what I'm struggling with. I feel like if we ranked it, I would be more inclined to put it at least a 2 than a 1, but I don't know.
Madam Chair,
Commissioner Schnell.
is injury, as it's stated here, is physical injury, or is it injury of a candidate?
It says it intent to injure a candidate.
By losing an election.
That's
Or
candidacy,
influence.
right? That's what I'm wondering if.
But it could, but it says injure a candidate or influence the results of an election. So I mean, my basic first year legal writing tells me or means there's 2 different elements there. So I don't know. Commissioner Middlebrook, and then I think Commissioner Larkin also wants to jump in. So
Okay, thanks, Madam Chair. Well, it also includes the gross misdemeanor if it's committed with the intent to cause violence or bodily harm. So I think it can be either or, which, broadens the conduct considerably depending on what they do.
Commissioner Larkin, did you have a comment?
Based on the discussion, I'm okay leaving it unranked. Thank you.
Is there a motion on the table?
Yeah, we have a motion to leave it unranked. Any other discussion? Sorry. All right, let's vote.
All right. To the Middlebrook motion to follow staff recommendations to leave using deep fake technology to influence an election unranked. Estrada? Estrada absent Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, it the motion passes unanimously.
All right. We're getting there, Madam Chair. All right. So, share this again.
Again, you found like a non-criminal chapter.
This was another one of those last minute nuggets. So you probably heard about the paid family and medical leave benefit insurance program. There is a felony tucked in there, which we're calling family and medical benefit fraud. I think earlier version of this is where we called it family and medical benefit insurance fraud, but again, modeling it after unemployment insurance, we thought maybe it would be a good idea to just call it family medical benefit fraud. So there's two subdivisions. One applies to the beneficiary, one applies to an employer, and it's exactly the same structure that you find in the unemployment insurance felony as well. So subdivision 3A says it's a theft to be punished under the theft statute to obtain benefits under this chapter to which the beneficiary is entitled if done by intentional false representation. So that it is a theft to be punished under the theft statute is something you see in the law, in Minnesota law quite a bit. So basically they're taking the theft statute's penalty provisions and adopting them. So they apply to this particular crime. And typically what the sentencing guidelines do with that is they list it under the theft offense list, which is a separate list we haven't talked about today. It's in section 7 of the sentencing guidelines. It lists all these theft crimes, and they're all treated the same. Basically, it's either a severity level 3 or it's a severity level 2, depending on whether the dollar value is over $5,000 or not. So that makes sense with respect to subdivision 3A. Makes less sense with respect to subdivision 3B, which says it's a crime and a fraud for an employer or other individual knowingly to make a false statement in order to avoid having to pay an employer's share, basically, or other purposes like that. It's a gross misdemeanor if the value of the fraudulent activity is $500 or less, and a felony if the value exceeds $500. Now, unemployment insurance, or the unemployment benefit crime, the commission's ranking kind of ignores that statutory distinction between A and B, where A is the theft if it committed by the beneficiary, and B is a fraud if committed by the employer, with the $500 cap. It's really the same thing, and the guidelines kind of gloss over that distinction and just lump the entire thing on the theft offense list. So that's the staff's recommendations, do exactly the same with this. So just as unemployment benefit fraud is placed on the theft offense list, we're recommending that family and medical benefit fraud be placed on the theft offense list. So it would be severity level 3 if it's over 5,000, again, regardless of whether it's an employer, employee, or a beneficiary, and severity level 2 if 5,000 or less, regardless of whether it's an employer or beneficiary. And then it would be placed on the theft offense list, which kind of incorporates all these rules here, which apply to every offense that's on the list. That's what we're recommending there.
Okay, any discussion or anyone wondering motion? Commissioner Larkin.
I move to adopt staff's recommendation. I think it's sound.
All right, do we have a second?
Second.
Commissioner Moore, seconds. Any discussion on the motion? I'm not hearing any, so we can go ahead and take the vote.
All right. The larger motion to place family and medical benefit fraud on the theft offense list for staff recommendations. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
that the motion is approved unanimously.
All right, we are almost done with 5A1, folks. Chapter 63 is cannabis. You knew it was coming. So let me just kind of describe what this does first with respect to controlled substance crimes. So with respect to controlled substance crimes, it eliminates marijuana sale. So there is no more mention of marijuana or cannabis in the sale provisions of the controlled substance crime. And it eliminates marijuana plants, which I think was just added in 2016. It eliminates marijuana plants as a quantity threshold. And it eliminates marijuana possession from fifth-degree controlled substance crime. But it retains marijuana possession thresholds for controlled substance crime in the first through third degrees. So marijuana possession in the first through third degrees become the heavy hitter offenses for marijuana. Those thresholds are still there. So I'm going to be talking about cannabis sale in a moment. But keep in mind, if somebody's really selling a large amount of cannabis, then the marijuana, well, I think they call it cannabis now, but the thresholds that now exist for first, second, and third degree will apply to that crime. So those quantities, thresholds are unchanged. The law also talks about, and it adds lower thresholds. So it changes marijuana to cannabis flower, basically, and then it adds lower thresholds for cannabis concentrate and various cannabis products infused with tetrahydrocannabinol or THC. So that's, it in some ways actually lowers the threshold for some marijuana crimes, now classified under controlled substance crime in the first and third degree. And it establishes 3 new felony crimes, each with a 5-year, $10,000 statutory maximum penalty: first-degree cannabis possession, first-degree cannabis sale, and first-degree cannabis cultivation. So each one of these crimes, it's a first-degree, like that. It tops out at a 5-year felony, which is kind of the entry-level point for the controlled substance crime scheme. Well, I guess they added a gross misdemeanor, but that used to be the entry level. It was a 5-year felony. But these crimes top out at a 5-year felony, and then they go down from there. So it goes gross misdemeanor, misdemeanor, petty misdemeanor, no crime. And here's the summary of it. So Table 6 summarizes the new post-August 1st, 2023 scheme for cannabis possession and cultivation. So again, we still have these possession levels: 50 kilograms or more is first degree possession, or I guess sale, since there's no such threshold for sale. 10 or more kilograms of cannabis concentrate, or 1 or more kilograms of THC infused in edible cannabis products. So it's not the weight of the products, it's the weight of the THC that's infused in there. Second degree is, again, this is an existing threshold, less than 50 kilograms, but more than or equal to 25 kilograms, but lower for cannabis concentrate and THC infused. And then third degree, less than 25 kilograms, more than 10 kilograms, but lower for cannabis concentrate and THC infused. So now we get to the new crime, which you're going to be ranking. We're not assuming any changes to be made to the controlled substance crimes, but these are 2 new crimes. I'm listing them in the same chart, but they're separate crimes: cannabis possession and then cannabis cultivation, which is listed in the far right column there. So less than 10 kilograms, but more than 2 pounds is the first degree crime. And then if it's cannabis concentrate, it's less than or equal to 2 kilograms or more than 160 grams. And if it's THC infused, it's less than or equal to 200 grams, more than 16 grams. And for cannabis cultivation, it's more than 23 plants. So this is the felony level. Anything below this is non-felony. If it's in a resident, then 2 pounds is there's that, drop from felony to no crime at all. So it's not a crime or a misdemeanor, petty misdemeanor, to have less than 2 pounds or up to 2 pounds in the residence. Outside of the residence, you have a gradually reducing schedule of thresholds. For cannabis flower, it's 1 pound for a gross misdemeanor, 4 ounces for a misdemeanor, 2 ounces for petty, which is a little higher than it is now. It used to be 1.5 ounces for petty. Or, I'm sorry, it was actually up to 1.5 ounces was a penny. So this is more than 2 ounces is a penny. Less than 2 ounces is not a crime. And then lower thresholds as for cannabis concentrate and THC infused. And we'll see this particular threshold, the non-criminal threshold, the 2 ounces of cannabis flower, 8 grams of concentrate, and 800 milligrams or 0.8 grams of THC infused. We're going to see that on the next chart, which is the sale chart. So these are the cannabis sale offenses. Again, we're only talking about cannabis sale because controlled substance crime eliminates marijuana sales. No longer dealt with in the controlled substance crime. So if somebody has more than the criminal sale threshold, significantly more than that, like if it's in the kilograms, you're going to be looking at a penalty under the possession statutes, not under the first degree cannabis sales statutes. You'll see a lot of references here to the criminal sale threshold. What are we talking about? We're talking about 2 ounces of cannabis flower, 8 grams of cannabis concentrate, or 800 milligrams of THC infused in edible cannabis products, low potency hemp edibles, or hemp derived consumer products. So that is the criminal sale threshold. And this, the cannabis sale offenses, it's all about that criminal sale threshold. If it's more than that, and so this is what you're ranking, right? So it's more than that criminal sale threshold to a minor by an adult more than 36 months older, then it's a 5-year felony. If it's more than the criminal sale threshold within 10 years of 2 or more convictions for second or third degree cannabis sale, then it's a felony. So we'll talk about what second and third degree are in just a minute. And if it's more than criminal sale threshold within 10 years of a conviction for first degree cannabis sale, then it's also the 5-year felony. So if somebody, say, for example, provides more than 2 ounces of cannabis flower to a minor, and then gets convicted for that, and then provides more than the criminal sale threshold to anybody, it's a 5-year felony. So that person would have two 5-year felonies, one after another. The gross misdemeanor is more than the criminal sale threshold in the school zone, park zone, or drug treatment facility. They don't have the public housing zone in there. More than the criminal sale threshold within 10 years of conviction for first, second, or third degree cannabis sale, which I find confusing. I brought this to legislative staff's attention. This is probably unintentional, but if it's within 10 years of a first degree cannabis sale, it's both second degree and it's first degree, which I'm sure they didn't mean to do, so they'll probably fix that. And any amount to a minor is a gross misdemeanor. So this is really the only exception to the criminal sale threshold. And criminal sale threshold is just a term I'm making up. It's not in the statute. And then third degree cannabis sale is any sale more than the criminal sale threshold. Doesn't have to be for money, just a sale. It's the same old definition that we've seen in controlled substance crimes, where a sale means giving away. It includes giving away or selling for remuneration. But then we get to the petty misdemeanor. If it's not more than the criminal sale threshold, but it is for money, it is for remuneration, then it's a petty misdemeanor. Or if it's to or by someone under 21, then it's a petty misdemeanor. If it's that same very small amount, and it's not for remuneration, and it's between people aged 21 and older, then it's not a crime. So if one 20-year-old passes another 20-year-old a joint, it's not a crime. But if that 21-year-old sells the other person a joint, then it is a petty misdemeanor. All right, so that's and there's lots of conforming stuff. It's an enormous bill, I'm going to jump to the staff recommendations. So, there were some changes to the tax stamp. Failure to affix tax stamps did not go away, interestingly enough. It replaced marijuana with illegal cannabis. So that's still a thing. Illegal cannabis, obviously distinguished from legal cannabis. So if somebody is legally engaged in the business of selling cannabis and being taxed under that scheme, then obviously they don't need to affix these tax stamps on their product. So we're recommending conforming changes with regard to the affixing the tax stamps, which is, well, actually, I think we probably should have changed 1 to 1A quite a while ago. So that may be more than a conforming change. That may just be catching up. And then cannabis cultivation and the commission did rank failure to affix stamp on illegal cannabis differently from the other ones. It ranked that at severity level D1, which the other ones are ranked up here at severity level D6. So a big difference there. So we're recommending just conforming that by changing the offense title to failure to affix stamp on illegal cannabis. We're recommending ranking these 3 new offenses at severity level D2. That's where controlled substance crime in the 5th degree is ranked now. These are also 5-year drug felonies, so it just seemed to make sense to rank them in the same place. And the final recommendation that we have, this is a little confusing. These medical cannabis violations, intentional diversion by patient. So what we're recommending is striking those because these provisions are being deleted. But they're not being deleted in 2023. They're being deleted March 1st of 2025. So what we're asking you to do is strike them now, but understanding that that has a specified effective date of August 1st, 2025. And that'll be on us to keep track of that and actually make that change in August 1st of 2025. But that particular change will not go into effect because that law is not being repealed yet, but it will be repealed in a couple of years. We're not recommending repealing it effective March 1st of 2025 because that would require publishing a whole separate edition of the guidelines on March 1st, and we'd really rather not do that. Any questions about those recommendations?
Let me just, actually, I think I need to correct what you just said. The crimes that are repealed will be repealed effective March 1, 2025.
That's true.
I think you said effective August, and so you're saying let's take them out of the guidelines now?
No, we're
Or
saying.
what are you saying?
What I'm suggesting is taking them out of the guidelines effective August 1st of 2025.
Okay.
So leaving them in a few months after they're gone, just because we don't want to publish a separate edition of the guidelines. So the 152.33 changes would take effect August 1st of 2025 as far as the sentencing guidelines are concerned, but nobody's going to be prosecuted for crimes committed between March 1st and August 1st because the crime will have been repealed.
That sounds reasonable. Okay.
Madam Chair, I would move the staff recommendation.
You adopted.
For that. Yeah.
Okay, across the board,
Across the-
all of them,
all.
every single one.
Every-
I'm just kidding. Okay, do we have Commissioner Schnell moves that we adopt staff recommendations? Do we have a second on that?
Second.
Commissioner Knudsen, seconds.
I have a quick question.
Commissioner Avery.
So for the cannabis statutes, is that a complete different statute than the controlled substance? And is it going to be completely on a controlled substance on its own and then cannabis on its own now? If I'm understanding right.
Yeah, so that's a great question. So sale is going to be on its own.
Okay.
So sale is now what you see in table 7 is all that's going to be, it's going to be first, second, third, fourth degree cannabis sale, or it's going to be nothing. But not so with possession. So possession is going to start off at a first degree controlled substance crime, which is our existing scheme. And then it goes down to second degree controlled substance crime, third degree controlled substance crime. And then it takes a break and jumps over to cannabis possession or cultivation. So if it's more than 10 kilos, then it's going to be under the old school controlled substance crime in the third degree, second degree, first degree, depending on how much it is. But if it's less than 10 kilos, 10 kilos of flour, marijuana flower, so like, you know, regular old marijuana. If it's concentrated, if it's like hashish or some kind of a edible or something in larger quantities, it's gonna be dealt with a different threshold, but, and by the way, any amount of plant, well, I guess you could still weigh it. If it weighed more than 25 kilos, it would be, or more than 10 kilos, then you can prosecute under third degree. But, so that's the breaking point for flowers is 10 kilos. So if it's more than 10 kilos, possession or sale, it's going to be prosecuted as a controlled substance crime third degree sale. I'm sorry, controlled substance crime third degree possession, regardless of whether it's possession or sale. And then if it's less than that, then it's going to be prosecuted as a first degree cannabis possession or cultivation, a new crime.
Okay. Thank you.
Commissioner Moore?
Thank you, Madam Chair. I'm saying this maybe somewhat facetiously, but I'm wondering out loud, was there any consideration of the possibility of creating a separate cannabis sentencing grid just because of the confusion here? I mean, prosecutors, judges see first degree, and what do you think immediately? Well, you think first degree controlled substance crime, and that can, what you just said is for possession, that's what we refer to, but not for sale. And then the first degree cannabis possession charge is the 5-year felony, as I understand it.
Yeah.
I don't know, it's gonna be a confusing array of provisions for probation and law enforcement and the district court to wade through. I don't know, I mean, just throwing it out there for discussion.
Well, I wonder if I know that you might want to answer that, but I wonder if rather than trying to do a whole separate grid, it might make sense to have something like table 6, which is in our materials, like in as a comment to kind of help people understand the relationship between all of these things.
Well, any help, any discussion would be useful. I know how important those grids are for the practitioners and the judges who are making, quick decisions on plea agreements and things like that. And this is going to take some time for people to get used to. It really is.
For sure. Judge Larkin, did you have your hand up?
Yes, I agree 100% because even as I kept reading and rereading, it took me about 5 times to figure out how you would get charged with a sale. You'd really get charged with the possession. This is very confusing. I kind of like the idea of a separate grid for it.
Nate is keeping quiet on that one. Commissioner Middlebrooks.
Thanks, Madam Chair. I think part of it's going to be how they structure the statute. The controlled how they put these in there. I think, am I right that they moved it to Schedule 4 also? The cannabis is now on Schedule 4
They did move the schedules.
instead of Schedule 1.
It's not Schedule 1.
No.
I don't, well, they kept some artificial cannabinoids, I think, on Schedule 1. I honestly haven't been tracking the scheduling. I know that's a separate article in there. I could look it up, but I know it's moved from Schedule 1, which is the non, prescribable schedule. So. But I mean, as a practical matter, it's not, I think universally, and I didn't talk about DWI and all that stuff, but I mean, as a practical matter, it's treated as its own thing. It's not generally lumped together with the, in the criminal law, it's not lumped together with other scheduled offenses. It's generally called out and treated specially.
So, another question, Middlebrook. Another question. So, on where they're staying under the controlled substance crime possessions, the 30-year felony, the 25-year felony, and the 20-year felony, are those amounts then going to be listed in the first, second, and third degree under 152?
Yes, those are, they're changing 152.021, 152.022, 152.023. those are being changed. But,
So then
or
we'll
not
be
changed.
listing, and then, so those statute provisions would be listed in our statutory provision and where they land for those crimes, right?
Right. Yep, and yeah, no changes are being recommended with respect to those crimes.
Okay.
Because under the statutory scheme, marijuana is just one of many different ways of committing that crime. So there's lots of different schedules. Our current statutory scheme just distinguishes between controlled substance crime in the X degree possession and controlled substance crime in the X degree sale, sometimes with some special aggravating circumstances thrown in, but it doesn't get into the weeds, so to speak, as far as different ways of committing that crime, possession, and different ways of committing that crime, sale.
Just one more.
Commissioner Middlebrooks?
Maybe just one more, rather than a separate grid, since it's gonna be on the same drug grid for those crimes, and then we have the 3 new felonies. Maybe a chart like this would be better in either, like you said, a comment or another appendix, rather than trying to create a new grid, just so that it's there for reference purposes. I don't know if that would be, it does seem like it's very helpful. I don't know.
And the other thought I had is that, I mean, there's definitely a training issue here, right? Like, there's gonna have to be CLEs and stuff on how to work with the new cannabis law. I know that you are typically at the Criminal Justice Institute in the fall. I know that we've got staff on hand that can also do training. And so this might be just something we'd want to also put a little effort into helping people decipher down the road, I don't know. But I like that appendix idea potentially.
Well, I would agree if we were going to do something like that. It should be an appendix. That's typically what appendices have been for, is things that aren't really part of the guidelines, but like this might be helpful to practitioners. It didn't seem, it didn't strike me that this was something that's helpful to practitioners at the sentencing phase. It's more like at the charging phase.
Yeah.
But
Yes.
Yeah, but
I mean, I don't know.
that's why I also raised charging, because I know that, I know I did, but maybe you have too, done training for prosecutors as well. So it's an option to maybe be invited to do a training for prosecutors on how to decipher this and where it gets ranked and all that. So anyway, so we have a motion to follow the ranking the way it's been done. Commissioner Moore, how do you feel about maybe potentially addressing the concern that you raised by moving some of this content into an appendix that we have in the guidelines for?
I would support that. I realize the notion of a separate cannabis grid is potentially confusing because you'd have overlap between the existing drug grid, and that could be more trouble than it would help. So I think Commissioner Middlebrook's idea and your idea is a good idea, to have a appendix with a chart that maybe could be helpful. That doesn't have to be part of the motion, but just for purposes of thought going forward here, to try to help everybody figure out what's going on here.
How, so I mean, it sounds like a good idea. How would you want to handle that? Because is it something that you want to move forward to public hearing, what that looks like, or how would you want to deal
Well,
with
I
that?
mean, so the guidelines put, I think it's section 3G, that it makes a distinction between the sentencing guidelines and commentary and appendices.
Exactly.
Like commentary and appendices aren't really part of the sentencing guidelines. So it, I mean, in theory, it could be something we'd look at the July meeting. I think if you wanted us to work on an appendix, you could probably vote on it in the July meeting and just adopt it effective August 1st. I don't think you need a public hearing. That's
been our.
It's consistent with my understanding as well. I just wanted to get your comfort level and how you would like to proceed if we're asking for you to move it.
I think commentary and appendix, I think we've got a basis in the guidelines for separately thinking of commentary and appendices from the guidelines. And we have sort of a historical practice of, at least with respect to commentary, not submitting those things always to a public hearing
Yeah.
in advance of publication.
I would agree.
Okay. Commissioner
And
Middlebrooks?
I'd agree on if we would use it as an appendix, it's very handy for, practitioners that I don't think that is, that there's any problem with that. We don't need a public hearing on that for that, an appendix like that.
Okay. All right, so then we're back to the ranking. And the motion is to rank according to staff recommendations. Is there any further comment on that? Hearing none. We'll go ahead and vote.
To the Schnell motion to adopt staff recommendations with respect to cannabis. Estrada? Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, it's approved unanimously. Is that the
All right.
last one in this packet?
That is the last one, unless I'm forgetting something. Please be the last one. Yes, that's the last one.
Okay, I
I have one more question.
yeah, go ahead.
Thank you, Madam Chair.
Commissioner Middlebrooks.
So, Director Wrights, on the list for the offense, the 5A on the offense severity on this, the same statute number is there for the failure to fix tax on illegal cannabis and Schedule 4 substances, it's the exact same statute. Do we need both of them? Page 51.
So I think that's a distinction that, let's see here. To look at the.
Maybe it's just something to check on.
So what I think is going on there, we talked about this a little bit with kidnapping, where I don't think there's a separate, I don't think the statute breaks it down by subdivision. 297 D. So the statute reads, a tax obligor distributing or possessing marijuana or controlled substances without, and I think it changed marijuana to illegal cannabis.
Okay.
Marijuana or controlled substance without affixing the appropriate stamps, et cetera, is guilty of a crime, 7 years, blah, blah. So
Okay.
what the commission did is it made a lot of distinctions that aren't found in statute, among, which always makes me a little nervous, but the commission did that. And so it distinguishes based on the schedule and based on whether it was marijuana or not, for example. And it's all lumped under the same subdivision 1.
Okay, temperature reading time. So we have finished A1, so we finished all of the rankings. Sorry, we finished 5A. 5A with
5A1.
5AB, 5A1.
5A1 was just now we're up to 5B.
5B. So 5B are the conforming changes. My question to the commission is, do you want to press on and see if we can get through all that? I think that's really what we have to finish tonight or this month. Or would you prefer to come back tomorrow and work on it then?
Well, Madam Chair, I don't want to come back tomorrow to deal with we've done all the tough stuff.
We have,
And we've slogged through it and great discussions. We've got other laws of interest to the commission, whether or not recommending any changes, no changes are required. I don't know that we need to deal with anything on that. And then we've got conforming changes. I mean, they're conforming changes to statutes that were passed, and I think we have to make changes that reflect the
yeah,
law.
we have to hit that packet. And so and it probably won't take that long. My question is really like, is everyone good with pushing through? Or
If we can move it along. I just don't think there's a lot of discussion on the conforming changes
All right.
on my review.
Does everybody feel the same, or is anyone?
Well, as the person who drives the furthest,
Yes.
I would prefer to not be here again tomorrow. If we can get through it fairly quickly, I think it would be productive, so.
All right.
We have a sleeping quarters.
In a cell?
Thank you, though.
All right, let's do it. And does anybody need a break, or you just want to push?
Let's go.
All right, let's do it.
So the first one has to do with bias crimes. So the act expands bias motivation to include categories of ethnicity, gender identity, and gender expression. Those are all new. It also includes partial but substantial motivation, which we'll see the guidelines already said something sort of like that. And then associated with someone in or perceived to be in one of those categories. So that's new. That could be very interesting, actually. Yeah, we'll see what happens there. So here are the guidelines ranking of severity of bias motivated crimes. So assault, if it's a second or subsequent, would be a gross misdemeanor normally. If it's done with bias, then it's a severity level 1 felony. Criminal damage to property, 500 to 1,000. Gross misdemeanor turns into a severity level 1. Harassment is a gross misdemeanor, turns into a severity level 4. Also, if any felony assault is motivated by bias, the stat max goes up by 25%, as does the guidelines duration recommendation. So this is the big change in 2D, 3B, 11, where the commission is listing optional, non-exclusive list of reasons that may be used for aggravated departure. It says the offender intentionally selected the victim or the property against which the offense was committed in whole or in part because of the victim's property owners or others' actual or perceived race, color, religion, sex, sexual orientation, disability, or national origin. So a little bit of a wrinkle here is 24410 subdivision 5A. In 2009, when all the Blakely stuff was going on, the legislature decided to copy the guidelines non-exclusive list of aggravated departure factors into statute. So that list is pretty much codified in statute. For some reason, I don't know. I don't know. But that list was not changed. So if the commission changes that 2D, 3B, 11, that's now going to be different from 24410 subdivision 5A. Is that a problem? I have no idea. I mean, maybe it is, maybe it isn't. I don't know that. Yeah.
I can comment on that.
Go ahead.
The legislature should never have put that content in there. This is our purview. I don't care if it's different. If what we say is different, I think in the future we should go back to the legislature and have them take all that out. That's my feeling.
I agree with that.
Second. Oh, I can't say that. Sorry.
It's a remnant of Blakely, and the legislature moved faster than the courts did to deal with Blakely. That's all it is. And I think at some point as a commission, we may want to tackle that and suggest to the legislature that they don't need that in there. They don't need any of that content in there anymore because it's dealt with in other places.
All right, so the big change here is staff's recommending taking the 2D, 3B, 11 and basically conforming it to the new bias categories that are found in all these different bias crimes, including, so right now it says in whole or in part, which was a feature found in the guidelines, not found in the statute. Now the statute says in whole or in substantial part. So it's kind of almost narrows down from what the guidelines say, but the staff recommendation is to add substantial before part, so it lines up with the statute. And then this first part is just changing the list to conform to the new list. And then the second is adding the new statutory thing, which is, or because of the victim's actual or perceived association with another person or group. Now, that may not actually be a change from the guidelines, because if you look at the guidelines, it says it was motivated because of the victim's, the property owners, or another's actual or perceived race. So maybe that's the same thing. I don't know. I mean, if somebody, has a sign up in their yard that identifies positively with one of these groups and somebody tears the sign down and commits, is that, I don't know if that would qualify under the existing guidelines, but maybe it would, maybe it wouldn't, and maybe it would under this change, I'm not sure. But that's staff's kind of don't rock the boat motion recommendation is just to conform. But you don't have to conform. And then there's, and then 2D308, I'm not sure if I understand what 2D308 was trying to say exactly. This is a comment. Staff's recommending when it talks about the victim's sex, including gender, sexual orientation, gender identity, or gender expression. I'm not sure if that's what they meant. I think the idea is if there are like crimes that like have as an element that, somebody have, a particular body part that is associated with women, for example, is that a crime motivated by bias against women? Well, maybe not. Maybe you have to look at some of these factors that are listed in here. But anyway, that's the recommendation, is to include that. And that, so those are the recommended changes. So to 2D3B11 and to comment 2D308, pretty much conforming with the statute.
All right, any discussion or motion on that piece?
I move the staff recommendation.
Okay, we have a motion for the staff to adopt the staff recommendations. Do we have a second? Commissioner Morath seconds. Any discussion? Hearing none, we can vote when you're ready.
All right, to the Schnell motion to adopt the staff recommendations with respect to bias crimes. Estrada absent. Ibrahim?
Yes.
Ibrahim, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
motion's approved unanimously.
All right, the next one is the redefinition of felony. And I apologize for this. This got a little mixed up. So it takes the definition of felony, which is a year and a day, and converts it to a year. And what we had done is we also sort of conflated that with crimes where the statutory maximum is a year and a day, and or crimes where the mandatory minimum is a year and a day. And those are really 2 different issues. So just because a crime has a statutory maximum of a year and a day, or the mandatory minimum of a year and a day, doesn't mean it's being changed by the redefinition of felony. So it just means that somebody could be sentenced to a year or a year and a day, I guess, for that crime, it would still be a felony sentence. So we're not changing anything about statutory maximums or mandatory minimums here. We're just changing any instance where the guidelines mention and a day. Essentially, it's removing and a day wherever it's talking about the definition of felony, not talking about stat maxes or mandatory minimums. So for example, here in 2BC2, it says the presumptive duration cannot be less than a year and a day. But it can be less than a year and a day because it can be a year and still be a felony. So we're deleting year and a day. And that's pretty much what we're doing throughout here, is just changing year and a day to a year. Or if it's talking about a gross misdemeanor, changing it to 364 days.
And taking out the little one from the 12.
And
grids.
taking out the little ones from the grids where little one meant a year and a day.
Great.
And 2E02, just full disclosure here, we're deleting a sentence related to 5th degree controlled substance time that really has nothing to do with a year and a day. I don't know why it was still there. We didn't catch it when the mandatory minimum was repealed in 2016.
Okay.
So that's staff's recommendation, Madam Chair.
All right, so we have a
I
motion
would
on
move.
that. Second. Commissioner Knudsen moves to adopt staff recommendations. Commissioner Ladd, second. Any discussion? and then we'll vote when you're ready. Oh, did I miss one? I'm sorry. I just kept the
Thank you,
Commissioner
Madam Chair.
Middlebrook.
I just have a question that isn't necessarily for these conforming changes. I'm not disagreeing with those, but at some point, maybe we have to look at how out-of-state convictions that would have been, gross misdemeanors, but now would be felonies, how that's gonna affect criminal history.
Yeah, and I think that was one of the changes we made. I mean, we're conforming it, so that would now be a 365-day out-of-state sentence would now be a felony.
Which I think is concerning, but if it's, so I don't know, I think that seems concerning.
That's, you say.
Commissioner Knudsen.
Would be.
I'm sorry, say it again.
I thought you said, Nate, what did you say?
So.
Isn't it 2B502?
Yeah, if you look at 2B502, for example, assault with a dangerous weapon committed in Texas that received a 364-day sentence would be given one gross misdemeanor unit to the sentence length despite being equivalent by definition of a Minnesota felony second-degree assault. So that's what we're changing here. Let's see, 2B502. So let's look at guidelines. And Judge Larkin's reading it. So let me find 2B5 here. I'm gonna just not make you sick here by out for a moment. Maybe you could ask Judge Larkin a question.
Yeah, Judge Larkin, why don't you go ahead and make your comment while he's looking that up?
Yeah, I was just gonna say, I share Commissioner Middlebrook's concern about this, but isn't this something we could fix this fall and then send it to the public hearing, the recommendation in January, or is that too late? I suppose that would be too late, right? Because things could come up beforehand.
Yeah, it would take a year for any changes to go into effect.
Yeah, and that's a terrific question. So here's what the guidelines say. Right now. So we should be looking at, let's see, 2B5B, which talks about it says how to count convictions from jurisdictions other than Minnesota. Find the equivalent Minnesota offense based on the elements. The section in which to count the non-Minnesota offense in criminal history depends on whether the offense is defined as a felony, gross misdemeanor, or targeted misdemeanor in Minnesota, and the sentence imposed. An offense may be counted as a felony only if it would both be defined as a felony in Minnesota and the offender received a sentence that in Minnesota would be a felony level sentence. So a 365-day, so let's say somebody's convicted in another state of an offense that's defined as a gross misdemeanor in that state, defined as a felony in Minnesota. The person got a 365-day sentence in that state. As the guidelines now read, that person would be given a felony point for that offense in Minnesota because it's defined as a felony in Minnesota and the sentence was 365 days. That's what that's saying. Staff's not recommending any changes to that. So if you'd like to make changes to that, I would suggest now would be a good time to make changes to that. You could.
Commissioner Middlebrook.
So as far as someone with a Minnesota sentence on a that was a gross misdemeanor, 365, that came in as a prior. I don't think it can be counted as a felony because I think that would be ex post facto, wouldn't it? I don't know. I mean, I'm just trying to figure out if we do the analysis for the out of state, but for Minnesota, it's usually, we just count them. We look at it, gross misdemeanor felony. But all of the past gross misdemeanors can't now be felonies, or that's going to be it's going to be ex post facto.
Well, if you're talking about Minnesota, that's a different question.
Right,
And
but
I
it
think the
seems that
law-
we should treat both of them the same to, as far as, I don't know,
So I think the law deals with past sentences already. So like whatever it was, it
Stays,
is,
right.
and it stays that way. But it's the out of state though, would be different.
Yeah, so it would be a current offense. I mean, the offense would be committed on or after August, for the Minnesota offense would be committed now. But then they'd be looking at the old offense, which may or may not be committed on or after August 1st of 2023. So like, let's say it was fleeing a police officer in a motor vehicle. Let's say that, I have no idea, but let's say it's a gross misdemeanor in Iowa and the person receives a 365-day sentence in Iowa. I don't even know if Iowa has such a thing as a gross misdemeanor. So, but it's definitely not a felony in Iowa. They receive a 365-day sentence in Iowa. And then in Minnesota, because fleeing a peace officer in a motor vehicle is a felony, and because the person received a 365-day sentence, then under the sentencing guidelines, as staff's recommending that they not be changed, that would be a felony for purposes of criminal history.
The Iowa offense.
The Iowa gross misdemeanor would be a felony because if you look on there, the first question is whether the offense is defined as a felony, gross misdemeanor, targeted misdemeanor in Minnesota, defined as a felony. And the second offense is the second factor is the sentence imposed, felony sentence, as far as Minnesota is concerned. That's the impact of this law change.
So can I ask a question?
Yes.
about that? So you're really talking about the fact that it's, when you say defined as, it's the elements, that the elements would have to match Minnesota and whatever that state was, and, an emphasis on and, the 365 or more.
And so then the issue becomes that in a lot of states, 365 is the max for a misdemeanor. So then something that, like what's probably more likely is something that was a misdemeanor there comes into Minnesota. If we call it a felony, it's gonna be a felony if they got that type of sentence.
Well, I just don't know if that was the intent of the legislature.
No, it wasn't. For that, I mean, nobody took that into account.
I guess the question would be like, how many of those, like how many instances would Minnesota call something a felony that another state calls a misdemeanor?
You'd be surprised.
Well,
Really? Okay.
I mean,
so what
No.
is the 365 days? If we sentence somebody to 365 days, it's not a felony.
Right.
well, I think July 1st is kind of the
Right.
end of the grace period.
Yeah.
Madam Chair,
Oh, I'm sorry, Commissioner Larkin.
thank you. So, okay, as I understand it, we historically treat the inclusion of the out-of-state conviction the same as it would be treated in Minnesota. Is that fair? If so, then it seems to me if we want to continue that practice, we would do something like saying in this bottom paragraph, instead of saying, and the offender received a sentence that in Minnesota would be a felony level sentence, we would say, and the offender received a sentence of 366 days or more. Because what we're trying to do is continue to treat that. We don't want to end up treating what is now a gross misdemeanor here as a felony, right? So if we just said 366 days instead of a sentence that Minnesota would be a felony, wouldn't that maintain the status quo? And I hate making suggestions like this at 5:09 at the end of a long day, but if we can decide this, I'll throw that out. I'm not opposed to the notion that we shouldn't have a change in how we treat out-of-state convictions just because the legislature did what they did. We should maintain the status quo. And if we would have treated something as a gross misdemeanor before, we shouldn't now treat it as a felony in response to the legislature trying to treat things less seriously. That seems completely inconsistent to do it otherwise.
Yeah,
I mean, part of the problem is some jurisdictions now do define, kind of in response to the same problem, which is an immigration law problem, frankly, as a federal statutory construction problem. It's some jurisdictions now define 365-day sentences as felonies. So it used to be a year and a day was always the felony definition, but now it's changed a little bit. So I
Well,
mean,
then, don't we address that by just, instead of saying, we don't care how they defined it, we're gonna look at what the sentence was in the other state, which is what I think we do.
Right.
So if we get away from this language about received a sentence that would be a felony level sentence and just say received a sentence of 366 plus.
I actually like that.
I think that makes sense.
I do too. Yeah, in that paragraph would be, and the offender received a sentence of 366 days or more.
Yep.
Which includes the
Equivalent of a stay of imposition. I'd leave the stay of imposition language there.
yeah.
I think that maintains the status quo. It would continue to do things the way we do now, which is to treat what is now a gross misdemeanor from another state as a gross misdemeanor here.
Would that be a motion that you would make? Oh, well, actually, we have an active motion on the floor.
So that was what I was just gonna ask. What is the active motion? So
Yeah,
you can move to amend a motion.
I would accept that
friendly amendment.
modification as the motion. I don't know who seconded it, but
Yeah, who's
I would make that, I would move to amend it. But if we get to public hearing and we discover problems with this and I come back and say, we hadn't thought of this, it's a problem. Can we discuss? I don't like doing stuff like this late in the day, but I think that's a place to start, at least for the purpose of a public hearing.
Yep. Okay. So how do we procedurally want to do this? Like, Judge Larkin, are you moving to amend, or Commissioner Schnell, are you just amending your motion?
whatever's easiest.
I'll move to amend to include that
Okay,
language.
she's moving to amend. How do we have to do this? I don't actually know the procedures.
Yeah, it's just a substantive motion, so
Okay,
she needs a second to it.
All right, so Judge Larkin is moving to amend the motion. We need a second on that.
Second.
Commissioner Middlebrook is seconding. Do we have to vote on that separately from the
Yes.
main motion?
Yes.
Okay, so then now we have to quickly, so any other discussion on this motion to change this language? Okay, we have to vote on this separately, then we can vote on the main motion. So you're gonna have to say it out loud twice.
Two votes for one action.
So, hey. So
So it would be.
So
difference
Larkin
would be-
moves in section 2B5B, Larkin moves to strike that in Minnesota would be a felony level sentence and substitute therefore the words of 366 days or more. So as amended, it would read, an offense may be counted as a felony and only if it would both be defined as a felony in Minnesota and the offender received a sentence of 366 days or more, which includes the equivalent of a stay of imposition, period.
Yep.
Yep.
Does that sound consistent with what you said, Commissioner Larkin?
It does.
It does.
Okay, great. Okay,
Okay,
let's do this.
the Larkin motion to amend the Knutson motion as just stated.
Wasn't it Schnell? I think it was Schnell.
I thought it was Knutson, I had Knutson, Ladd, felony staff recs.
That's correct.
Oh, is that right?
Okay.
Okay, I'm
I
sorry.
guess- I
It was
guess-
so long ago, but I remember.
To the Larkin motion to amend the Knutson motion, Estrada absent, Ibrahim,
Yes.
Ibrahim, yes, Knutson,
Yes,
Knutson, yes, Ladd,
Yes,
Ladd, yes, Larkin,
Yes,
Larkin, yes, Middlebrook,
Yes.
Middlebrook, yes, Moore,
Yes.
Moore, yes, Morath,
Yes.
Morath, yes, Schnell,
Yes.
Schnell, yes, Chair Mitchell,
Yes.
Chair Mitchell, yes, Madam Chair, there are, oh, stop doing it, there are 9 votes in favor, no votes opposed.
Okay, so that one's approved unanimously. We go back to the main motion on ranking I'm sorry, not, I'm making the other conforming changes for the change in the definition of a felony. Commissioner Moore.
I just wanted to say this was a good catch on the part of Commissioner Middlebrook. I used to practice law in Iowa, and so when they mentioned the misdemeanor thing, I went back and relooked at the old definition, and serious and aggravated misdemeanors are up to a year in jail. In the state of Iowa, that would be a felony under, I think, the definition now. So it's, I think, probably does merit a little more thinking and studying prior to the public hearing to just make sure there isn't something we're missing here. I'm a little uncertain about the state of imposition aspect of that, but otherwise I support the conforming motion here.
Excellent. All right, any other discussion on the main motion? All right, seeing none, we can vote on that.
To the Knutson motion to adopt the staff recommendations with respect to the redefinition of a felony as amended, Estrada absent, Ibrahim.
Yes.
Ibrahim, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell.
Yes.
Schnell, yes. Chair Mitchell.
Yes,
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
with that, the motion is approved unanimously.
Although my spreadsheet stopped doing the math automatically for me, I must be out of motions as far as it's concerned. All right. Okay.
Probation cap.
Probation cap. So, where am I? What page is that, Madam Chair?
That is on page 11.
Well, I'm looking at the guidelines thing. All right. Okay, so as the commission knows, it established a presumptive probation cap for non-homicide and sex offenses in 2020. The legislature takes that list and instead of a presumptive probation, 5-year probation cap, creates a statutory limit on probation of 5 years. So really, it makes the presumptive probation cap unnecessary. It also adds a new offense, 609-749. It also creates a floor for those offenses of 4 years. So currently, there's a 4-year floor that applies to all felonies. It gets rid of that 4-year floor, and now the 4-year floor only applies to offenses on the list, which the only offenses on the list that it affects are criminal sexual conduct in the 5th degree. That's the only felony that I know of on the list that has a stat max below it, and not all versions of that offense, but there's at least one version of that offense that has a stat max below 5 years. So any other offense that has a stat max below 5 years, now the maximum period of probation instead of being 4 years is the stat max. So for example, fleeing a peace officer in a motor vehicle is a 3 year and a day stat max. That will now be a 3 year and a day maximum period of probation. It does add one offense to the list, criminal vehicular operations, substantial bodily harm, for the purpose of getting it with that 4-year floor. So now, even though that offense has a stat max below 4 years, it will continue to have that 4-year maximum period of probation because it's been put on the list. We're recommending making conforming changes, which is essentially getting rid of everything you did in 2020 for the most part. So it's rewinding the clock. We do have some language in there. So 3A1, so we're getting rid of 3A2, which is the length of stay. And we're mentioning in just one sentence in 3A1 the whole thing about the length of stay. So the court must pronounce the length of stay which may exceed the duration of the presumptive prison sentence, which was in there already, but may not exceed, but not the maximum length of stay established in statute. This is the new statute that's being created. Getting rid of 3A2, so 3A3 goes back to being 3A2. And we also just make conforming changes in the commentary.
All right. Discussion or motion on these changes? Commissioner Middlebrook?
I'll move to adopt the staff recommendations.
Commissioner Middlebrook moves to adopt the staff recommendations. Do we have a second?
I'll second.
Commissioner Schnell, I heard first, second, and then Commissioner Larkin, did you have a comment? I saw your hand go up later.
I was just going to second.
Oh, perfect. Okay, sorry. I'm sorry, I missed that. Okay, any discussion on the motion? Okay, we're ready to vote on that.
All right, to the Middlebrook motion to adopt staff recommendations with respect to probation lengths, 5-year cap codified. Estrada absent. Ibrahim,
Yes.
Ibrahim, yes. Knutson,
Yes.
Knutson, yes. Ladd,
Yes.
Ladd, yes. Larkin,
Yes.
Larkin, yes. Middlebrook,
Yes.
Middlebrook, yes. Moore,
Yes.
Moore, yes. Morath,
Yes.
Morath, yes. Schnell,
Yes.
Schnell, yes. Chair Mitchell,
Yes.
Chair Mitchell, yes. Madam Chair, there've got to be 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously.
I rely on spreadsheets to calculate my age, Madam Chair, so I'm kind of at a loss here that it doesn't add it up. All right, so the next one is the targeted misdemeanor list, which adds obscene or harassing telephone calls, or does it? We don't really know. So it adds
Oh,
609.749 obscene or harassing telephone calls. Unfortunately, obscene or harassing telephone calls is 609.79, and 749 is stalking and harassment, which there are no misdemeanors in stalking or harassment, so it would not be necessary to put it on the targeted misdemeanor list. So I don't know what you want to do with this. I mean, you've got a couple of options. One is you could just pretend like it didn't happen and wait for the legislature to fix this typo. I believe in talking with the legislative staff that this was a typo. They meant 609.79. Your second option is to add 609.79 with an asterisk that says, literally it said 609.749, but we believe this was the legislative intent. The third option is you could add 609.749 obscene or harassing telephone calls, an offense that does not exist, and add an asterisk that says, we believe the legislature intended 609.7.
Sounds good.
So I've got the second option here recommended, but any of the 3 options is reasonable. I've got 609.79 with an asterisk that says literally 609.749, although that citation appears to have been a typographical error, and I've got a reference to the enacting statute.
Commissioner
Sounds
Mitchell.
good.
I move to just ignore it for now.
Second.
Commissioner Middlebrook wants to ignore it for now. Commissioner Schnell seconds. Any other discussion? So we'll fix it next year, in other words?
Yeah.
Okay. All right, any discussion on that? Do we really need to vote if we don't take an action, or?
I think it's probably good form. I'll try to do it
Okay, go
fast.
for it, go for
Okay,
it.
to the Middlebrook motion to make no changes to the targeted misdemeanor list, Estrada absent. Ibrahim,
Yes.
Ibrahim, yes. Knutson,
Yes.
Knutson, yes. Ladd,
Yes.
Ladd, yes. Larkin,
Yes.
Larkin, yes. Middlebrook,
Yes.
Middlebrook, yes. Moore,
Yes.
Moore, yes. Morath,
Yes.
Morath, yes. Schnell,
Yes.
Schnell, yes. Chair Mitchell,
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
With that, the motion is approved unanimously.
Right.
Okay, so the other pieces that are in here do not require conforming changes. Was there anything that jumped out to anybody that they want to talk about right now?
Yeah, these are in here because I think a reasonable commission member might think that they required. I'm not recommending any conforming changes, but I can see where you might think it does need conforming changes. One is the MRRA and the juvenile early supervised release eligibility for juveniles. Those kind of are playing havoc with the truth in sentencing laws, which Minnesota sentencing guidelines talk about the 2/3, 1/3. It's sort of 2/3, 1/3, but is it really after this? So I'm not recommending any conforming changes, but maybe this is something you want to talk about with more time. I mean, I'm not sure what you would do if you wanted to make a conforming change, but I'm not recommending anything there with respect to 1. With respect to 2, there is some new language regarding probation revocation restricted. There's some last resort language and some, technical violation language. Guidelines 3B does talk about reasons for revoking probation. So kind of covering the same territory. They talk about, kind of treading lightly in this area and so forth, but they don't have the last resort language, so maybe you want to put that in there. I didn't think it was really necessary, but it's certainly reasonable to disagree with that and decide that you do need to put some of that statutory language in 3B. So that's it for that, Madam Chair.
Hearing nothing on that. All right, so the other piece in our packet was the laws that don't really require conforming changes. I think we go over that in July unless there's anything that like really jumped out at people that they feel like we need to talk about today.
Nope.
Okay, so not hearing anything there. I would say then, let's just skip to, is there anything in your update that we need to hear today?
Well, yeah, so there's the NAS conference in August. I don't know so these are all kind of related issues. I don't know who's going to be on the commission. I mean, right now I got 2 people who I know are going to continue to be on the commission. So, one of them is going to get an invitation to the NAS conference. I don't know if you're going to be the chair. So as soon as I know that you're going to be the chair, you'll get an invitation to the NAS conference. But yeah, so that's a sticky wicket. And the governor's office, I don't know exactly when they're going to do it. They just told me they weren't going to do it before this week, because otherwise that would have played havoc with this meeting, because there's like a 5-day waiting period and whatnot. So I just don't have any information for you. I apologize for that. Talked about the NAS conference. We are going, I talked about personnel moves because of the law being passed. We've got funding now for a research supervisor. So I kind of put all personnel moves on hold, and we're trying to find a research supervisor. So I'm just going through the new position description with HR right now. I'm just trying to work through the process, but hopefully we'll get that job posted very soon and get that person on board.
Commissioner Moore and then Commissioner Middlebrooks.
It would be good to, Madam Chair, at some point, now that the funding's been approved for the comprehensive phase 1 review, I know it's early and we're not going to talk about that today, but just to have a sort of a discussion about scope and what the thought process is on timeline there, just so we have a little better sense of what we're going to be getting into there down the road.
Yep.
Madam Chair, I was hoping we could do that tonight.
You're going to be in that sleeping quarters pretty soon. Keep saying that. Commissioner Middlebrooks. Thanks, Madam Chair. When is the national conference?
It's early August. Let me,
7th and 8th, 9th,
sounds about right. I can find it here.
creeping on it earlier.
It's
Yeah, 7th through 9th.
7th through 9th.
Okay, thanks. Okay, anything else?
No, Madam Chair. So members of the public, please raise your hands if you have any, if you'd like to make a public comment at this time. You should be able to raise your hands on your, well, let's see, you might have one. Staff members, if you could please raise your hand so I can tell that that's working. All right, Madam Chair, there's one person dialing in on a phone. I better just make sure that person doesn't need to raise their hand. Otherwise, nobody else is raising their hand. All right. Whoops.
I see somebody's hand.
Oh, I see somebody's hand up. Okay. Let's see. Damian Kusian, do you wish to make a public comment? Not hearing anything, so I'm going to mute Damian Kusian. All right. Desiree Oakley, I see your hand's been raised. I'm going to unmute you. All right. Madam Chair, I've unmuted Desiree Oakley.
All right, welcome to the commission. Please go ahead and make your comment.
Hi, my name is Desiree Oakley. My son Josiah Oakley was killed in a car accident on December 11th of 2022 on the corner of Lindale and 42nd in North Minneapolis. I kind of been trying to listen to you to see. He was hit by someone who was unlicensed because of a previous DWI. The person was 3 times the legal limit, going 90 miles an hour in a 30-mile-an-hour zone. And 3 times his alcohol limit was 3 times the legal limit. He ran a red light and basically killed my son on the scene. I'm going through the process right now of court. The prosecutor, wanted to offer 48 months because they say that based on the sentencing guidelines, that's about the max that I could hope for. Which is kind of appalling to believe that you can take someone's life in such a reckless way and not have consequences. And the prosecutor in their office is telling me this is within the guidelines and it's the guidelines that suck. And so we have the sentencing is scheduled for the July 3rd. And I know obviously I can't make any changes, but if this person goes out and does this again after serving maybe 2 years for the 48-month plea, it's, I don't know. It's just, he's obviously shown that he drinks and drive in the past and he didn't learn anything because he was basically slapped on the wrist that first time. And I'm being told that nothing that happened in that case in 2019 can be used in this case to make it, a longer sentence. But the sentencing guidelines for max of 57 months is horrible I think it's a level 9. I'm sorry, I'm kind of doing yard work and been listening to you guys, but I just went to the last meeting and wanted to voice my concern to see if you guys are at all considering like whether aggravating factors can push this to another level, or why is a loss of life in a vehicular homicide like this given such low?
Well, thank you for your comments. We don't have it on our agenda at this moment to look at how those crimes are ranked, but we are about to engage in a comprehensive review of the guidelines. So certainly those are the types of issues that we could look at. I really appreciate you putting in your public comment today, and I would urge you to also put your thoughts in writing and to send it to the commission so that we have it in front of us as we are engaging in that process and sort of what you think we should be doing. We're going to be seeking feedback on places where the guidelines should be reconsidered. So I would invite you to submit further comments.
And I mean, I've kind of already addressed all this in a letter to the Attorney General's office, but it didn't go anywhere really because, again, they are following the rules and the guidelines. It's just, to me, you see the crime, vehicular manslaughter can do up to $20,000, 10 years, but then you look at the sentencing guidelines. And I mean, unless he had several felonies or something like that, he would never get that. So it just seems so strange that you would say a crime holds this, but then yet the sentencing guideline be so much less.
Certainly, I understand. Anyone else want to make any comments? Well, thank you very much for coming in today. Oh, Commissioner Larkin, please go ahead.
I just wanted to thank her for her comment and note that this isn't the first time we've heard this from a member of the public at a meeting. And I certainly hope that the commission is willing to take a look at criminal vehicular operation comprehensive review, because I mean, this is one area where I'm sure we all can agree that people demonstrate that they pose a risk and consequences are important.
All right. Is there any other comments for today? Okay. Well, hearing none and seeing no other individuals who'd like to make a public comment, I just want to thank the commission for all the work you put in today. Really, really nicely done. It was a lot. I really appreciate all the prep that clearly every member of this commission did coming into today that allowed us to get through this work in this day, in a single day. With that, we are going to cancel the meeting that we had scheduled for tomorrow, and I will adjourn this meeting. But I just want to say before I do, public hearing in July. Can we check the dates on that? There's a public hearing in July, and so all of this material will go to public hearing. That public hearing is on July 20th. And then we have a meeting 1 week later on July 27th. We don't require a quorum on July 20th, but I encourage you all to be there if you can. And we do require a quorum on the 27th because that will be the date for final adoption of those changes that go to a public hearing. All right, with that, the meeting is adjourned. Thank you very much.